all reading the same thing. They'll give us a heads up.
Technical difficulties.
Good morning, everyone. I certainly want to thank those who are in attendance with us today, both here and those who are watching from the comfort of their home. Today's date is October 27th, 2016. Notice of the October 27th, 2016 meeting of the Board of Examiners for Land Surveyors was posted to the Board of Examiners for Land Surveyors website on March 22nd, 2016, with a revised agenda posted October 20th, 2016. All right, a little bit after 9 o'clock, we're going to call this meeting to order. First item of business today is to adopt the agenda, which I hope everybody has in front of them, had an opportunity to review. Any changes or additions to the agenda? Speak now.
I don't see any.
Hearing none, I'll entertain a motion to adopt the agenda as printed.
So moved.
Motion.
Second.
And a second. Any final thoughts? All right, that with a voice vote. All in favor say aye.
Aye.
Any opposed? All right, the agenda for today is adopted. Next item on that agenda, review and approve the meeting minutes. I believe those were from the July 28th meeting. I believe you should have a copy of those included in your packet or perhaps on your iPad. And I trust that you've had an opportunity to review those minutes as printed. If there's any changes, additions, revisions, deletions, et cetera, et cetera.
Mr. Chairman, in the minutes from the July 28th meeting,
Yeah, Tim.
in the legal report, after case number 4, I think that's a typo.
Okay.
I think that the board decision should be, that board decision should be removed, and the correct board decision should be in place there. Because this, if I remember, this was unlicensed activity, and I don't see how the board could ask an unlicensed E to have 16 hours of continuing education. So I do not recall, I apologize, I didn't bring my notes with me today, but I do not recall what our board decision was, but it should be inserted there if possible.
And that is item 4, is that correct?
Yes, sir, that's
Okay.
correct.
All right.
And that is not a problem. We'll be able to watch the video. I'll make sure that we get the right information and change it and replace it, and then bring those minutes back for the board to approve at the next meeting, if that's okay.
Yeah, that'd be fine.
Unless you're okay with legal counsel making the change and then approving them now, that's up to you.
That's where I'd like to go
Okay,
with it.
that sounds great.
Yeah. All right, so we do have a one item there on item 4 that will be handled by staff. Any other changes to be amended? Hearing none, I'd like to entertain a motion to accept the minutes as printed with the amendment brought to our attention by Tim, will be handled by staff. Is there a motion to do so?
So moved.
All right, we have a motion
Second.
and a second. Any further discussion? Hearing none with a voice vote. All in favor say aye.
Aye.
Any opposed? All right, so accept those minutes as amended and to be handled by staff. Okay, next item we have is the education report.
Could I interrupt again?
Mr. Chairman,
Yeah.
if I may, we have a second group of minutes from October 5.
You're right, I forgot all
That
about
needs to be
those.
addressed, please.
I do recall those. Right, yeah, on the October 5th. Let me see if I get those in here. Yes, you're right, my bad. Thank you, Tim. Okay, separate item, the minutes for the October 5th, 2016 meeting in which all were present. Any changes, revisions, additions, deletions?
I make a motion, we approve as written.
All right, motion?
Second.
And second by Galen. Any final thoughts there? All right, hearing none, all in favor say aye.
Aye.
And opposed. All right, thank you, Tim, for that. Skipped right by that.
Chairman Coffin, I wonder if I can interrupt, and we've got the Assistant Commissioner here, if he could do a quick
Absolutely, yeah.
welcoming, and then he'll guide us, and we can then continue. I'll turn it over to you. Thank you.
I get my nose out of the iPad, I see that. Thank you, Brian. Yeah, absolutely. Go right ahead.
Thank y'all. It's good to be back here in front of you. I hadn't seen you in a few months, and so glad to see how things are going. I see we've a new member, Summerford, here. I think she's going to be a great addition to your team, so I'm glad she's here. I just wanted to take a minute. I think all of you all are probably aware of this, but wanted to kind of update you sort of on where we were and make myself available for questions, which I know is always dangerous here. But I wanted to talk about sort of the transition. I know the last time I was before you, I was here kind of helping with the administration, and then Roxana, you all have been working with, I think, very seamlessly over the last few months. And so she has been, she's been promoted to the position to which will have her working with you all full time on this board, and so she will be serving as the director for you all full time. I think you're gonna. It seems to me from the feedback I've received, this is going to be a great thing for you all, and I know she's very excited and has really dove into the material. I've just been very happy to see kind of the collaboration and the work that's going on. I'm hearing of a lot of great things, and so I'm really, really excited about that. Wanted to be available for any questions on that, but also just wanted to take a moment to kind of recognize a couple people, I think, from our staff. I know you all know this, but Cody has just been an absolutely fantastic help in the last. I mean, he stepped in some ways that someone in his role wouldn't typically be asked to do, and he did, and so it was very much appreciated by me, and I just wanted to make sure I recognize that to you all for the performance. I think you've got a great team here with Roxana, Laura, and Cody, and I've got a lot of people that are going to follow me today from my group that are going to be talking with you about various things. But I'm really excited about the direction we're headed, and look forward to kind of moving forward.
Great, thank you, Brian. I'm sure it was a sign of your infinite wisdom in the appointment of Roxana, and certainly, of course, of Cody some time back. But I think I can speak for the board here in saying that with Roxana on board, and certainly the rest of the staff, continue working with them. Thank you.
I'll see you later.
Thank you.
Thanks, Brian.
Thanks.
All right, we do have some other guests here. Did we want to take their business first?
If you would like, we also have Ms. Sue Grayley here with us. If you would
Certainly.
like to,
Absolutely.
I welcomed her. It was a pleasure to get to meet her today. So if you would like to address her, that would be fantastic.
Absolutely.
Too.
Sue is certainly no stranger to this board, having served, I believe, for 12 years as a public member. And I say public almost with a set of quotes around it, being that her father was a longtime surveyor here in Tennessee, and certainly she was raised up in the environment of surveying, which is certainly a blessing in my aspects of it. But we wanted to take an opportunity today to congratulate her for her 12 years of service, but also especially to thank her for the years of dedicated service, of taking her own personal time and serving on the board here. As Ms. Betsy will learn, as a public member, it is a little bit time-consuming, but it is a passion, certainly of the members of the board here, to serve on this board, and a pleasure and a privilege, especially above all, to serve with the fine people, both and to serve the surveyors of the state of Tennessee. And Sue has done that above and beyond for many years, and we certainly want to thank her with that. I think, Cody, do you have a plaque today I think we're going to present to her?
Yeah, let's go up front.
Absolutely. Let's go ahead and step up front. Maybe we can get a picture with Cody there.
Give it to Jay. I'll get this right here. Yeah. Come on here.
Absolutely.
Fun.
Keep tearing it up. I think my wife must have wrapped that.
Get a picture first. Let's get the picture taken. Get you in here.
say that Sue brought to our board what a public member brings. That was her job for the last 6 years. She would elbow me. She cut it off. And Sue's claim to fame on applications is that was her claim to fame, that you were automatically out if you had a wife beater
Out.
t-shirt.
Okay.
And I'm gonna miss it, I've enjoyed it, and
Sue, I certainly want to, on behalf of the board and all the staff and
Thank you very much.
it's nice meeting you.
Lunches at the farmer's market, so.
Send me a copy of that picture. I need something hard next year, okay?
Doing some skipping around, so I think if the board is okay, we will do our next
absolutely.
speakers. But I do want to do roll call real quick. I skipped it this morning because we had Brian here, so if that's okay, just to have it on the record. If I can start with the chair, James Kaufman.
Here.
Timothy Lingerfeld.
Here.
Ms. Betsy Summerford.
Here.
And Mr. Galen Northcutt.
Yep.
All here and accounted for. Thank you very much. And we are skipping a little bit to go ahead and take advantage of Kimberly Whaley that is here and Michael Driver. They are going to talk to us about the RFP program, and more importantly, the next stage of the exam piece that we discussed also in October. Thank you. So if you can. And everyone has received 2 pages that are regarding kind of the points that we want to discuss with this. And Kimberly will walk us through it. These are the 2 documents that you're looking for. Thank you both for being here.
Thank you so much for having us. We're excited to move forward with the RFP and looking at the exam and how to take it. Just a little bit of an update. We have successfully secured an amendment, and it is currently going through all the signature process. Administer for one last time as part of the old contract the exam, which will be in March. Before March 30th. He will give the exam one last time. I don't believe the exact date, but again, keeping with the contract that expires March 30th. So we are good until March. So that being said, what you have before you, the portion of the contract related to the specifics of what the board wants and needs out of a testing vendor is in the scope. And the document itself is rather lengthy and very legalese. So what we've done is we've cut out the portions of the scope doc where we need to gain the board's input as to how you would like to proceed in the future. So, did you?
No, I think you have a one-page document there prepared by Ms. Whaley that does a really nice job of setting out those issues that we've identified as potentially up for discussion in our internal discussion. The scope document that you have with you now is written as the exam is currently given, which is 2 times a year in person. With the same sets of questions. I think there are 6 different fields that are supposed to be covered, and a mixture of essay exams and a review of a plat. And I think what we wanted to talk to you all about is if that's still how you wanted to proceed. We have other contracts that we let for, I guess, what I would say are on-demand testing vendors. There are some companies that give those where we can put out a bid and request that companies have a certain number of sites around the state. We've done that with other RFPs we've given and be able to give the exams on site. I think some of our discussions were we were not sure in the current scope of the contract that something like drafting a plat would feasibly be part of that sort of on-demand exam because of the nature of what we thought would go into reviewing that portion of the exam. And so those were the sorts of issues we wanted to bring before you, is if you wanted to move forward with letting the exam as it's currently been given. I think the 2 times a year was previously chosen. It's always my feeling to align with the NCEES exams that were also being given by that same vendor up until very recently. Also, the number of questions on the exam is 30 questions. Just to bring that back to you all, since this is your chance to consider if that's still the number of questions you want, if 100 is still the number, the item bank you would like. Like I said, some things we've discussed internally. As of right now, the cost of the exam is set at $150 per applicant by rule. Ms. Martin has, I think you all have some other rules coming before you today, and as part of that, just for your discussion, we, I think, included in there the possibility of allowing that to be set by vendor contract in the future. The vast majority, to my knowledge, of boards and commissions do these sorts of contracts in a way that's revenue neutral to the board, what's called a no-cost contract, which is essentially the applicants to the board pay, you know, whatever the accepted vendor is willing to give the exam for, and the board doesn't provide any cost directly to the vendor, which has not been the practice of this board. But as of right now, that $150 is set in rule, as is the passing score of 70%. So any vendor that accepted this contract would have to abide by those, at least until such time as any rule change took effect, if this board decided to do that. And at that time, we could consider an amendment if the board did want to change those things. And to be clear, none of this is to beg the question or to ask you to change these things. It's just now that this contract is up, now is the time for you all to discuss what you want from your exam, what the Tennessee jurisdictional exam, what its role is, if it would be potentially better for it to be the sort of exam. I know some vendors have the ability for people to book an exam. You know, they have computer banks and they can book it, I think, the day before on some of our exams and walk into the facility and take it 24 hours later. Again, if you wanted to keep the current scope of the contract.
Very good. It looks like you've done pretty extensive homework on that. We certainly appreciate that. Any questions off the top of your head on this?
Give me a second to read through all of
it. The one that does bring question to my mind, it refers to the top 2 topics there, the method and the types of questions. The given on demand when the applicant has met the requirements to test, I'm comfortable with that. However, when you drop down to the next level, the types of questions, item number 2, for on demand, there would be need to switch to 100% multiple choice. If I understand that correctly, that implies that there's 2 different Tennessee state-specific exams. One would be on the scheduled dates, which would include the essay responses, et cetera, et cetera. However, if there's one on demand that's only multiple choice, or am I misunderstanding that?
I think how the document was intended to be structured is the top bullet point is generally, at least on those top 2, is how the current scope of the contract, and the second bullet points were the ones that were drafted as to what an exam could look like.
Could look like, okay.
Yeah.
The method of giving the test, you at this point you have sort of 2 options. You can continue with your current structure, where you give the exam in April and October. That one's the first example.
It's the first, yeah, right.
The second one is that you can switch to some version of on-demand. That could be using a on-demand vendor who has testing sites. We have several different contracts with people who do that. You could look at doing sort of a take-home correspondence test as kind of a hybrid between the 2 methods, but those 2 are, you pick one or the other. We don't want people going to the testing center and having to come take a second exam. So, and there's a couple of other benefits, with your 2 times a year, the person has to travel to a very specific location. Historically, I believe it's been in Murfreesboro. So you've traveling from extreme East Tennessee and extreme West Tennessee, coming, having to spend the night, etc. With an on-demand or correspondence type exam, the person would take it and would never have to travel very far from their home. Most of the vendors have testing sites throughout the state, and that's one of the pieces that is part of that type of RFP is they have to speak to how they can provide the service, where they provide the service.
Okay, so essentially we're talking about computer-based testing on that.
That would be
That's what I thought, yeah.
It's a computer-based testing. With that, you would need to look at the ability to switch your questions to all multiple choice, because you would have a strict schedule of this is the right answer, this is the wrong answer. There would be no gray area for that. Currently, I believe you actually have the person draw some things. The plat and the subdivision are the 2 items mentioned. Additionally, essay questions. The on-demand computer-based testing, they don't really allow for that when you're using that method, because you're not using an evaluate those.
And again, if I understand this correctly, this is strictly for the RFP, giving the potential vendor the option of giving the exam in either way. Is that correct? We're not mandating a specific.
No,
way.
we are. In order to release the RFP, we have to select a method
Okay, all right.
that you want to give the exam.
Okay.
So
And
that's
you
going
can
to be up
change-
to us to select that method.
Yes, sir.
Not
Yes, sir.
the
And if
RFP.
you wanted to give it 4 times a year, you wanted to give it 6 times a year, it's either computer-based testing on demand
Or zero.
or correspondence,
Thank you.
or the set number of times per year.
I think I'm comfortable in saying we can answer that pretty quickly here. I don't know that we're quite ready for a computer-based testing on the Tennessee state-specific exam quite yet, because of many of the reasons that you stated. So I think I'm pretty comfortable in saying that we're going to need to do this still paper, pencil, sitting down type thing, and not a computer-based. I'm sure at some point, as the exam evolves and the CBT testing becomes more available, I think we'll certainly want to strive to get to that point. I just don't know that we're ready quite yet for that. Certainly is a goal, but I just don't think that by the time this contractor is under contract that we would be quite ready for that. I just don't know that we are.
Again, you can choose to do it more times a year. I will point out one piece with your current structure. It's a very expensive choice for the board.
The current structure? Really? As opposed to the whole setup of a CBT based?
CBT based would be a no-cost contract to the board, whereas the existing contract with your fee at $150, the board itself is covering probably nearly 60% of the expense to test an applicant. $150 does not cover the board's expense to administer that type of test.
Based on the small numbers of testees, yeah.
Yes, sir. You average about 23 people per exam, 45 per year. So you're spending $1,000 each year to administer the test, while only recouping the $150 currently set in. Just full disclosure of what this is, because in the negotiation of the contract, we were told that there's a good bit of, fixed cost to administer even just the 1 2-hour exam. I would anticipate probably your cost would probably stay somewhat the same here.
The anticipated length of this contract to the vendor? Is it a 4-year contract, 5-year contract?
We can do.
We don't know.
Yeah, we can do anything from a 1-year contract. Of course, a 1-year contract for examinations, not generally great because of the instability that it creates for the board. I think on average, we usually start with a 3-year contract, and we can usually extend that for up to 2 years on a year-by-year basis. After that, up to a maximum of 5 years. And my understanding is that's generally from our central procurement rules, as long as we're allowed to have an individual have a contract without bidding that, just with the state's general preference for continued competitive bidding of these sorts of things.
Thoughts?
Well, I've got several comments. I'm probably losing the order that I had them in. I wanted to address a few things that Ms. Kimberly had said. First thing I wanted to address was you spoke to the inability of computer-based testing to be able to utilize the subdivision type question, the drafting type question. For what it's worth, I'm on the exam committee for NCAAS, and we have innovative item types that are part of computer-based testing that will address the very issue that you discussed as a weakness. So I just wanted to point that out for that's what it's worth.
And that's something too. My comment was based more in the types of vendors that I'm speaking to are they're experts in giving tests, and I wanted to make sure if they couldn't accommodate that I didn't oversell their abilities. And I know NCAAS, there may be a program or something they've utilized that a vendor potentially could piggyback off of. So most of our other boards though are the multiple choice. Happy to look into that because we would love to move towards the computer-based testing because again, we are looking at our licensing times and how long it takes an applicant to become licensed, and the on-demand testing allows the applicant to, closely couple their education, their experience, their time potentially in Tennessee to taking that exam as opposed to with someone in January and they can't take it until April or even October, you get that drift. So.
Okay. Now let's go back to addressing.
Phil, could I ask you a quick question on that with the exams with the NCAAS? For the map type of question for the drawing, are you talking about the computer system allowing you to drag and drop those kind of things? Okay, so I think most computer-based people that would reply to an RFP of that nature would be able to add that. I get what Kimberly's saying.
I think they would.
I think they all would.
uses Pearson VUE, PSI is very similar.
Absolutely.
And so forth.
And we can absolutely, if that's something you think is possible, I don't fully understand. You guys are the experts as to how that could be achieved. So absolutely, we can build it in there.
In respect of that, Mr. Kaufman is 100% correct. Currently, our item bank and the structure of our exam is not ready for that, but I think within the realm of potentially this contract, if it was X number of years versus 1 or 2, that it would be important that that transition be able to be made. Because I mean that's where we need to be. I hear you saying that, and I agree with you 100%. But as Mr. Kaufman said, we're not totally there just yet because we've got other issues to discuss here. One of the paramount issues is we'll go down to exam review, and I'm going to jump around a little bit. It says examination items and materials to the board for its review. We determined in our last meeting on October the 5th that is not feasible. It's not practical because we can't sit here as a group in this meeting and review an examination and speak to anything on the examination because every applicant is going to watch this video and listen to what we're talking about. So,
and if I may, that's just the current wording of your current contract.
I understand
that. That wasn't the last bullet point where it doesn't say current contract. That's more of a general. I believe Roxana has spoken with you about the process that she uses with cosmetology that could be implemented.
And that's correct.
I just wanted to make sure that the current versus the future state.
Well, I wanted to point that out to you in the dialogue because I assumed that was the purpose of this document, so we could discuss it and point these things out because on that particular issue, where we're currently at from our previous October meeting was that there would be a board representative. So that dialogue needs to change. Such that it's handled in the manner that Ms. Roxanne suggested at our last meeting. And I totally wholeheartedly agree with that based on the rules that we have to function under.
Yes, sir. No, absolutely. Again, this was just to present to you what is currently there, understanding we had that conversation and that you had a conversation also with Roxana about how that could be achieved and the collaborative nature of that, working with the experts, the subject matter experts as well as the subject matter experts for testing. So that's
and clearly clearly the existing contract we have was pre-CBT for the FS and the PS. So, in effect, our existing contract is a dinosaur contract now because we've went way, way past it. But what I want to say to that regard, going back to the first item on the list, is about the number of times taking the examination. With the PS examination now being given every day of the year by NCEES, I feel that it's incumbent on this board to be able to administer our examination more times than the current 2 times that we currently do. We had bounced around in prior meetings about 4 times. In other words, basically once quarterly, because that's more in tune with how we meet, review applications, etc. And it's also a situation to where an individual in the pipeline of licensure by the examination process would be able to more quickly take the examination than under the standard format that we have now. And hopefully it could be graded quicker as well. Now, in speaking to that, we had discussion at several meetings relative to the possibility of administering the exam here in the department. Now, this was before you, Ms. Roxanne. And with the current format of the exam, I think that it could be reasonable as a transition method from where we currently are to where we hope to go. In other words, to say currently we're 2 times a year at the site selected by the proctor in the Nashville vicinity, and as you amply said, you had 45 applicants taking those 2 exams for $20,000 plus, okay? Well, what I would look at would be one way of making a savings while we're looking at making a transition, but obviously it's up to Ms. Roxanne and staff if they're willing to do that. The prior director and staff indicated it was, no problem whatsoever to do that, which that could even be as frequent as any schedule routine that Ms. Roxanne and her staff would want to use about that. Because basically what we as a board would need to do would be to initially use the same exam that we have, and there's multiple versions of that, but the same exam we have, and basically the staff or department would provide an office of where that exam could be taken, and someone on staff would have to monitor that, or basically be a proctor, and we would make the examination closed book, so that basically the only thing the person would be bringing into the exam would be a calculator that's approved, which is no different than the way it is right now, and a pencil. That's basically all they would be bringing in to take the examination.
Is it currently open book?
Yes, ma'am.
Okay.
Yes, ma'am.
I just wanted to clarify there that they can bring in the current thing, but the current exam is open book. Okay.
Yes, ma'am. Yes, ma'am, it is. So we would be looking at taking basically the same exam. This is just a thought, in taking the same examination, but in-house at the staff's pleasure of schedule relative to when the applicant was approved and so forth, and using that as sort of a interim measure from where we are to where we're going. And I know this is all probably very new to you, Ms. Roxanne, but I certainly yield to whatever your thoughts are on that.
If I may, one of the items currently in the exam, the vendor grades the exam. Who in this scenario would?
The vendor still would.
The vendor would.
Yes, Ms. Roxanne would put it in an envelope and send it to the vendor,
Okay.
wherever the vendor's at. If he's down the street, he can come by and pick it up. If he's somewhere else, she mails it to him.
So the vision, if I can kind of recap and see that I'm not lost, would be to the current contract, not make a drastic change while we work on our base of questions. And we follow that step kind of in the next year to 3 years, whatever that time frame is. And we work on those heavily and do everything that needs to be done for a good database to move toward the computer base. In the meantime, the contract would be very similar to what we have, but 4 times instead of the 2. So anyone bidding on it, which could be the current individual and 2 new individuals that think they can do that, they would be grading it. They would follow all those things. They would own the questions that we have.
They
No.
would not own the questions. We
do.
And that was one thing I was
Well,
going to
that's
say
right.
is we do have the base. If
Yeah.
you were to consider the CBT this round, we do own those questions. So you have a starting point to begin evaluating. Those questions can be handed over.
The problem with the base is this board has not seen the base. That's the problem. See, that's the way things used to operate in a faraway land in an ancient time. The board got to do those, okay? But the rules are different now, okay? And we're wanting to follow those rules. So we've got to. That's the whole thing is we don't have our arms wrapped around our examination. And fortunately, we have a tremendous individual that has the contract presently, that is the proctor and the writer of the exam, and we have full faith in Mr. Messier because he's done it for 22 years. And it's been very successful, and we have not seen any ill effects or ill signs from any registrant or anything else because of the exam process and how that's all went. So we're looking at the potential of changing vendor, and which is fine. I mean, everything changes. I understand that. But we've got to be able to wrap our arms around, or at least one person on the board has got to be able to wrap their arms around what's there and what they are, because we don't do any psychometrician analysis on any of the examination questions. We rely totally on Mr. Messier to do that, and he does a tremendous job. I don't question anything that he does. But what I'm saying is, in this process, as we move forward, there's a good likelihood that we may have a different vendor, and as we get through this transition scenario, we might have another different vendor after that, because they may find that it's not, cost effective for them, for example, and they don't want to rebid it and it changes again. So what I'm looking at is to try to take what we have and what we're trying to accomplish and put it in a structure that we'll be able to move and progress as our technology continues to change, as we continue to have different things within the department and so forth. That's my goal, is so that we stay ahead of the game. We are way behind. We are way behind with this examination structure, application administration. And I look at me on the board as much my fault as it is anybody's fault. But I want to get that corrected to make this better for everybody, the department, the staff, the board, and the person that's taking the examination.
And I guess what I will say is, so far as giving it here, I would have a number of concerns regarding things like exam security, potential open records requests. There's a number of things that go into proctoring an exam that people who proctor exams know about. And this is not meant to be any sort of slight to the people who would be doing that, but there's an amount of training that goes into training people to notice certain methods of fraud that are common during examinations that, say, I wouldn't be attuned to noticing, having not been trained in those things. Things like applicant fraud that would come in that would have to go through Roxana's staff, although I admit they're familiar with some manner of applicant fraud. It's a different sort of thing in checking to make sure that the people coming in are the ones who say they are and what they're doing during the exam and those sorts of things. What I will say is we have a lot of times the computer-based testing contracts, they require the vendor to generate the bank of questions. And I don't know of anything, and look, I'm not psychic, I don't know, if you get a bunch of bidders, if you get none, but if what the board wants to try to do is say, this is a computer-based exam, this is what we expect of it, we expect the vendor to generate, psychometrically valid questions. You mentioned 2 vendors who do that, and there are a number of others across the nation who specialize in doing those sorts of things for exams in virtually every field imaginable. And you put those things in the contract and say, look, this is what we expect from you. We expect you to defend this exam if someone questions the validity of it. We expect you to develop psychometrically valid questions. We expect questions to be on, these 6 topics. We expect there to be, I don't know if it's how to word it exactly, but an interactive, question that has the person fixing, a plat map on through the computer-based testing system. I think we can write an RFP that asks for those things. And if that's where the board wants to be, my concern is if you push this 1 to 3 years down the road, where we may actually find ourselves is actually in 1 to 3 years having this exact conversation again and not having moved in the direction the board wants to move. And so maybe the course of action in that case is to just try to put in the RFP what the board really wants in that RFP, if that is what the board wants. And we'll put that out there and see if any test vendors are interested or willing to place a bid to perform that service. And that would be, maybe my recommendation on that front.
Michael, what would happen if, let's say, we do put an RFP on the streets for CBT testing, and we spec it out, and we don't get any responses?
Well, that's ultimately the risk, right? Because you would have to then do a different RFP. Yeah, I mean, that's ultimately, and so that's the balance of these things. I think, if you bid the exam out now, you will likely get responses. I don't know. I mean, this is just me. Again, I have no magic knowledge, but, you look at the number of people taking the exam and the cost with developing the exam and the fixed examination fee that goes into the exam. And there certainly are, I think, some challenges with bidding it out as a larger scale. But I do think we have had vendors in the past accept. I don't know how the number of applicants compares to this board, but some smaller examinations as opposed to something like contractors or cosmetology, which have thousands and thousands of applicants. But we do definitely have vendors who take and provide exams on smaller professions. So, locksmiths, private investigation, polygraph examiners. So, I think Kimberly's telling me are provided through relatively small and provided through computer-based testing. So, we have had at least some success in the past in somewhat similar circumstances.
Mr. Driver, may I ask a question, please?
Please do.
I know you want to try to get an RFP out probably as soon as possible because we're looking at a March 30 deadline of this existing contract terminating. The question that I have, and I wish it was information that you were armed with today, and you may be, is what is the exam going to cost the examinee if we go computer-based testing based on all the factors, and you nailed them, based on all the factors that we're talking about, because my concern is earlier in the conversation, the language was used to make it a no cost to the board, and I understand that, and that makes very good sense. But what I have learned through NCWS is on a jurisdictional basis across the United States, the survey and examinee numbers are so low that CBT basically is somewhat cost prohibitive on an individual jurisdictional basis. So based on fuzzy math that I did a minute ago on what Ms. Kimberly gave us, we're looking at the exams costing us about $500 a person, basically.
It's upward. I think it's upwards closer to 550.
Okay, well, I'm just using
But
round
by the time
numbers.
you add in grading,
Right. And she has all the numbers, but in general, talking, we're in the same place. I'll say 550. Okay, our current exam is costing 550. The applicant is basically paying us 150. So the board is supplementing a large amount of that examination. But what my fear would be to go CBT, and that exam costs $1,500. And that's what I see. So that's kind of why that.
And I will say, if we let an RFP, my understanding as I sit here today is, at the end of the RFP, you either give it to the lowest bidder, or you can just say, this didn't do what we want to do, and you can wash out the whole thing. So if the lowest bid you got was $2,000 an exam, and you all look at that and say, no, absolutely, we've got to figure out a different way to do this. I'll also say the way this exam is proctored now, that cost included proctoring and providing the NCWS exam for 10 hours or whatever that wasn't involving this exam. And I'm not saying that's not a valuable service, but there's a large amount of time, at least hard fixed proctoring time, that isn't involved in this exam. There are also a number of fixed costs that have to do with setting up a facility and those sorts of things to give a fixed time exam that if a company is a testing center company, they've already kind of spread those costs out because that's their business model.
Just to, in respond to that, our exam, our 2-hour state-specific exam is given tomorrow in Murfreesboro. And that's it. That's all he's doing tomorrow is just that 2-hour exam period. Where has done the others before, but they've now went a different direction.
But the way that contract was originally
still, right,
did,
and you're exactly right. The way that contract's structured, it's a very expensive adventure.
But I will also say, I don't want any applicant to ever be at a place where they cannot take the exam, obviously. But even though the current contract runs in March, under the structure as it's been, from my understanding, for years and years and years, in the best case under the previous contract, no one will be taking an exam again until October of next year. Following the
Since we have mandated the existing contract to happen in March,
correct,
in lieu of April.
Right.
Which is a good thing.
But
I think we
yes,
did the right decision.
Yes. So we've got some time.
But
It's
what
not
I'm
March yet.
saying is, if we did go, and I do not want this to happen, for an extra 3 or 4 months and weren't able to put another contract in place until, God forbid, August of next year, with the first exam being given in October, the actual current exam schedule, well, not optimal, I admit, would not have actually changed. And I guess that's just to say we have more wiggle room than we do in some other situations where we've had similar contracts coming through where people are used to on-demand testing, and those contracts are at a risk of running out. And then you have people who are counting on taking a test a week after your current contract runs.
Hey, let me ask you this about the contract, the RFP rather. Let's assume that we're all happy and you've got all the details you need and you're going to send it out. That may take you, another week or something to send it out? For example, and I'm just making the assumption everything's good shape.
Right.
It takes more than that. There's a
Well, that's what I'm saying. That's what I'm trying to get to.
There's an internal process, just full disclosure.
I'm trying to get a timeline.
Right.
Yeah.
What I'm trying to get is, okay, if everything is good today,
Right.
give me a timeline as to sending it out, when you expect to get it returned, and when this board would see it to speak to it.
An actual RFP, like before it's let? Is that what you're asking?
No, sir.
Or
No, sir. I'm asking if you had all the data today to
Right.
create an RFP
Yes.
for the situation we're discussing.
Yeah.
When would it go out? When would you expect it back? And when would the board review the results?
Results
Is that
of
a
the
fair question?
The results of
Yeah,
the
yeah,
people
no.
bidding on
Yes.
it.
Is that a
the
fair
bid.
question?
I mean, what is your experience been? 4 to 6 months is pretty
Easily
normal.
at least 4 months because
4
they're
months
all
is-
given a timeline to present the documents and in
That's
this
what I'm
case
asking.
come
Yeah.
up with questions.
That's the
Yeah.
question.
I think 4 to 6 months is
Because I don't know how they function, so I'm trying to learn.
Yeah, no,
Yes.
absolutely. No, I think 4 to 6 months has been my
Is
experience
realistic.
of a well-run, good, efficient RFP process.
And now, to fill in that, but would the board be able to see the applicants that respond? Is that, I mean, I know that we've got contract folks that review them. They're always redacted, so we don't know who's
The
responding.
RFPs go through, there's a state set review process where there's a review panel set up and those people get
Right.
the contracts and get a rubric, I guess, for scoring the exams that is meant to ensure that the person who meets the qualifications
So
the best.
Let me go back to the question that I asked. So
Okay.
Is Ms. Roxanne's answer including this delay time that Ms. Kimley's speaking about?
No, yes, that is. That's what I was speaking
Wait a minute,
to.
you said no and yes. Which is
No, yes,
it?
Roxanne.
You said it again. Which is it? Does Roxanne's 6 months
Yes,
include
Roxanna's 6 months
everything?
would include everything.
Okay, that's my question.
Yes,
That's
sir.
what I'm trying to get my arms wrapped around.
But you, I don't believe, and I think that's what Michael just said, you would not be able to see the contracts that are coming in for bid. To maintain the redaction, the fairness of it, what the state has to do, it would be the contract folks. And right?
So-
As I
so-
understood Mr. Wingfield, though, you
Okay.
just meant to see who won
Okay.
at the end of the day, correct? But
Yeah, I
you
understand.
just want
No,
to see the
no.
result of it.
No,
Yeah.
I understand, because here's what I'm trying to vision in my mind, and my mind's very small, so help me with this, is if we make a decision and have a format for the RFP that
Right.
everybody's comfortable with, we could then expect, and for all intents and purposes, this is November 1, okay? So you got November, December, January, February, March, April, okay? So in all intents and purposes, if we made that decision today, you all, the state, the department, would be thinking about getting it back sometime April, May. And then you would vet it through your process. Every how many of them that are returned, they would be vetted through the proper process, which means that we would not see an RFP for a contract basically until our August meeting, which is what you just said.
No, I think the 4 to 6 months is for the entire process, responses,
That's what I'm
review,
trying to get, but I'm getting
and
I'm
winner.
getting it in pieces parts here. That's what I'm trying to get. I'm trying to wrap my arms around. So what you're saying is we would get there would be information to potentially be presented to this board in May, for example,
Probably
based
I
on
mean,
the timeline that you're mentioning.
potentially February or March would be my hope. So 4 to 6 months, 4 to 6. So 4 months would put us at the beginning of February into March, and with the information we would have, one, if we got no bidders, that process shortens considerably because we know that much sooner than we know the results of the review process and those sorts of things. And two, I would expect we would have a vendor in place sometime between February and April, which is 4 to 6 months.
That's what I'm trying. We're building at my question backwards. I'm getting my answers, but we're going at it backwards on my time.
I'm an attorney. The only way
Yeah.
I know how to do
Okay,
things
that's
is
fine.
backwards.
That's
I'm
fine. No,
afraid.
that's fine. That's fine. I'm getting my answers, but they're coming. They're coming in different intervals. They're coming in different intervals. So what I hear you saying now is that somewhere in maybe February or March, you may actually have something.
Correct.
That you have a vendor if they have met our criteria,
Correct.
and then we would have to approve them whenever our next meeting was.
There would be the state contract process. Once you let the RFP,
We're done with it.
it's
It's out of our
done.
hands, yeah.
Okay.
It's gone.
That's the piece I was
Okay.
getting at, that you really wouldn't be involved in the next phase. Once we determine that, yes, we're going to trust them on the database of questions, and eventually we're going to get our group together and come up with more questions and keep building on that, right? So we can keep adding to that database. But in the meantime, while the RFP lives its course, then the state would select it, committee gets review, and we would be told maybe at the February or April meeting, we're ready to go. Here it is.
And then you would have the opportunity to, the one, as Roxanne, I believe, has stated in the past, a board member, one at a time, would have the opportunity to meet with the experts at the testing company to, again, begin that whole process of adding to, changing, updating, whatever it is you need to do once you have a vendor in place.
Work on
That's
those
part of the
questions.
process. Then you would have, a stated first date of examination.
Question. So the scenario I threw out about the staff giving the exam, is that out the window?
Well, Michael pointed to some concerns, and I think that Brian has addressed some as well. The meeting that I didn't attend in July, that although we do it currently, we do have one board that's very small, and we do it twice a year as well right here. The thought, because we'd like to go to 4, and even with those 2 a year, is Brian's perspective, and I get it, is we should veer away from that.
I certainly wish that a prior director had not spent a lot of board time with that scenario and got our mindset pointed in that direction as a potential option. And I will just simply say that, and that's a fact.
I think one of the biggest things that it goes to, Mr. Lingerfeld, that you mentioned earlier, that I think you were talking about, if everybody talked about it all at once, it really does, us having that opens it up for public records request. Security, would have to expose your questions. So
And security is paramount. There's no question.
right, and
about
that's, I just want you to know that that's one of our biggest concerns, is that if we had that, then it might open us up. Whereas the vendor having it and the vendor maintaining it, they have the security there. So we never have the test, to put it simply.
Okay, so let's reverse course then. We basically, as I hear what you're saying now, we have two options: status quo, or look to go to the on-demand exam.
Let me ask you a quick question on the RFP. When we all come to a consensus agreement before it gets sent out, all right, we've published a final. This is what it's going to be. We're almost ready to send it out. Does this board get the opportunity to review that RFP? I think it should.
And I mean, we were hoping to have that for you today, and these questions came up.
Right.
And I think, I know it's generally disfavored and the administration may get ill, but I mean, you know, there are means in the meetings law to allow boards, in cases of necessity and time-based things, to do telephonic meetings that are still open to the public and have to be noticed, and all of those things that we've done in other situations to ensure that we can continue working on the timelines, and you all would still get a copy of it and be able to discuss telephonically, and maybe avoid the cost of everyone, and both in money and in everyone's time, and coming in for potentially an hour or 2 hour discussion or 30 minutes or whatever. But yeah, I think it was everyone's intention for you all to see the final RFP before it ever went out.
And I certainly think we should. I know that what we were submitted today was the first rough draft of even though there was considerable effort, I appreciate everything, but obviously
Yes,
we've got a lot of questions evolving
It was
from it.
to sort of, once you decide staying status quo or going CBT, that's where you really get into the crafting. You know, do you want to stay with 100 test questions? Do you want 30 test items? Do you want those interactive questions? Those types of things. That's really where we can craft. So the sort of the uncertainty of the direction of the board, I know we've kind of been talking about it. So that's kind of where we're at today, to let you know why you don't have truly the scope piece. These are the pieces of the scope that, in order to truly need some input from the board on. So.
Well, I will say too, just to put some oil on the water and make it a little smoother and what have you, but just so you understand and know too, and Tim knows very well, there's only about 3, 4, maybe at most 5 states that have gone CBT with their state-specific exam. So that leaves the rest of us, we're dragging up the cow's tail, what have you. But I'm like Tim, I think it's time that we're moving on toward the CBT, but it may take more than just what we are thinking about going through a year or 2 or 3 years for us to get into this thing. And frankly, I think status quo, let's go with the thing, and then we have our input, whatever the question, number of based questions that we have, move on with that, and then we can make a decision based on what's coming up next. So.
Yes, sir. I understand that. I do want to say one thing. Currently engaging a CBT vendor will give you access to their expertise that Mr. Lingerfeld was talking about, being able to evaluate the questions. I believe you've sat on the NCAAS, and you know how valuable the vendor's input is in how people respond to the questions. You have your distractors. They're experts in that, and that the CBT type contract would allow you to engage them almost immediately, as opposed to it will be, I don't, getting to the next stage of the CBT, I'm not sure what that actually looks like. So I do have some fear, as Michael said, we may be back here a year or 2 or 3 having the same conversation if you choose to go that route. I'm just laying out some of the pros and cons. The board, of course, so up to you. But I do think the CBT vendor could provide you a lot of value in helping you write those questions. The industry has moved into those. Again, I was underselling what they could do just to make sure we didn't say they can absolutely take those PLAT questions and make them exactly how you want them, because that's part of the RFP process, is to lay that out and say this is what we need, and they can then respond to that.
Ask you a question. You spoke, someone spoke earlier about some smaller boards doing on-demand examinations. What, if you can say, would be your experience relative to the cost of those small examinations?
I believe it's, as Michael spoke, your PSI, your Pearson View, I call them the professional on-demand testers, to not exclude any of the vendors that are out there, because too, we see new vendors all of the time that are getting into the business. They've got their expertise in some sort of thing. Typically, it's scalable, because they're going to give this exam, and you're going to be sitting next to someone taking any other exam. You could be sitting next to a person taking the cosmetology exam. So their scalability with that, I think some of it is in question development, could be, and if the board wanted to offset that, we could potentially talk about paying directly for that service if there was a need to keep it at, if your rule says that it's $150, we could directly say the exam can be no more than $150, and they know that up front, and then the board is willing to pay for the question development. That's an option.
Well,
right? That we could pursue, given there is some concern with the cost. I don't know right off the top of my head, because really, I think beyond geologists, everyone uses a professional vendor to do the testing, correct?
Correct. And many of the vendors will bid because they have a larger program, so they realize they can't charge $1,500. So, and this board right now is picking up so much of the cost anyway that we already have the cost built into our, course of running business. So to some extent, at least in the beginning, we can pick up some of that to get that database of pools, to pay for our volunteers if they have to come in person and we're having these meetings. That can be one of those costs of doing business, knowing that in the long term, we won't have those expenses. We will have a better, stronger database, and we'll just be looking at those questions that are kicked out for review.
Next question. Do you have, or do you see or observe some commonality in the on-demand providers through the department? In other words, is company A doing 5 tests and company B is doing 2, and then company C, D, whatever?
We do have, there's probably a couple of large 2, maybe 3 vendors who have it, most of the contracts. But we, again, as I spoke, I'm typically one of the reviewers. I've reviewed, 3 or 4 RFPs in the last 6 months, and you'll see new people breaking into the industry. And again, some of them are specializing in a certain type. They're wanting to be the premier contractor, licensee test provider, and they'll.
Obviously,
They're all very comparable in their services they can provide. You do have that scale of the people who are in multiple states. We have a vendor who, I had a gentleman who needed to test in Idaho. He needed a contractor's license in order to install a piece of equipment. I called PSI. I said, I shouldn't have said that.
You didn't say that.
PSI, Pearson View, any of that. I called an on-demand vendor, and they were able to provide me with 4 or 5 locations near him and tell me, when does he want to take it? Okay, I have this many seats available at this location on this day, and I have this many at this day. So, we have that total on-demand and across the country. So there's some big benefits, because right now you probably have people who travel from other states to take the Tennessee exam. So you think about how much the exam is truly costing them to take. Whereas if we had that scenario, Roxana could call the vendor and say, we have this need. Can you fulfill this? So,
as concerned about increase in fees and things of that nature, they have equal concern about the examination fee, or is that just a?
While it's a pass-through fee, I would be surprised if some people were not concerned with ongoing thoughts and questions about people being able to get into professions and those sorts of things. If there substantial increase in the cost of a professional exam. While that might not be an issue from a state contracting perspective as a pass-through fee, it might cause other concerns regarding increasing the burden and difficulty of entering this field if there was a substantial increase in the cost of the exam, for sure.
And I think also one of the points I made earlier, we have to consider we're seeing a face value cost of $150. We're not seeing the cost of travel, hotels, meals. So that exam that we're charging them $150 for, could be costing them by the time all is said and done. You probably don't want to drive in the day you're taking the exam. And I know I'm a person, when I'm done with an exam, I just need a nap. So potentially that person is staying another night. And so right there, you have probably close to $300 or $400 in hotel bills to take the exam. So there's, that visible cost and sort of that hidden cost. So something to be considered with the on-demand testing, because they can do it closer to home. They can do it any day of the week. They're not having, they can make arrangements. The child care, if someone doesn't drive, they can make arrangements to be taken to the site. So
let me see if I can just kind of wrap this in a little bit, because obviously a lot of discussion here. Very good discussion, I might add. First of all, I want to ask, are you looking from this board today how to proceed with the RFP in terms of two options? A, somewhat status quo, the way it's kind of been, maybe a few refinements, or B, taking the leap to, look, it's time. At some point we know we're going to have to do this. Why not do it now, jumping over to CBT and all that encompasses? That's what the question is that right?
yes, sir, because that will drive the remainder of the scope.
Yeah, absolutely. Okay. With that in mind, I just kind of want to play a little bit of devil's advocate here. Tim, I think you and Galen and quite honestly myself are a little bit hesitant to go into CBT, just because I don't think we as a board and we as a collective group of the board are ready for it in terms of all that it encompasses. But as devil's advocate, I think we also agree that we have to get there at some point. I think we can all say that at some point this test will be administered CBT. And so why not now? That's kind of my argument.
As a new board member, if you could, I understand the importance of a plat to the exam, and if they could do that electronically, but like it keeps being brought up, how are we not going to be here in 2 years? It just seems to be the natural progression, and I'm also kind of surprised that it's an open book test. So, shocked, because how does that test your knowledge? But at the end of the day, what is your all's biggest issue with keeping it the way it is versus going this new route? Because if they can get the plat information into the test, it seems to benefit the test taker infinitely, as well as the state with cost and that sort of thing. So I guess what's the biggest perk of keeping it the way it is when we know we have to go this route?
Yeah, you made good points and a great question there, Betsy. I think it's probably fear of the unknown, quite honestly. With our main concern, I think I can speak for all of us here, is that the applicant is treated fairly, in a fair manner, and is tested in a fair manner, which we believe currently is and has been for quite some time. This is a whole new leap of faith here, and we know we have to make it, and it's just kind of the hesitancy that relying on this vendor based on this RFP that we need to generate will be able to do just that. We'll be able to administer a CBT exam that is fair to the applicant, that is fair to what this board deems is a qualified exam, covers all the bases it needs to, has the ability of drafting plats, et cetera, and is cost efficient. Number one, to the board, cost efficient, but more importantly to the applicant, that we don't have a $1,500, $2,000 exam fee, which is just unreal. And it's the unknown of, can that be done? That's narrowing it in, especially with the cost factors. But we know we got to be there at some point. We're going to have to be there. And so the question begs, why not now? Why not take that leap of faith, put a lot of faith on whoever this vendor that's ultimately selected is, putting a lot of responsibility on them with them saying that, yeah, we can do what's in this RFP given the guidelines that this board approves. Why not? Why not?
To address, the fairness of testing, I don't believe anyone has ever questioned the fairness of our exam, or
and that's a credit. That's
or
a credit,
the integrity.
It's a compliment.
These vendors they have sophisticated state-of-the-art cameras. So as far as someone being able to cheat on an exam, I don't believe we've ever even had a claim of someone doing that. So it is definitely, a huge step in the technology. In looking at your questions and the fairness of the fairness of the exam in the questions they're giving, that would be a random generation. Each person, if Michael and I were sitting next to each other taking the test, we're not going to be taking even one version, or we're going to be taking a totally different version, because each time they do it, it's going to be that generated version.
Which would require a pretty substantial database of questions, which is put on the vendor themselves under the approval of, it has to be one at a time, of the board reviewing the questions, saying that, yeah, those are acceptable.
And that's where you go. You have your base of 100, and then you would review your base of 100. You may have questions in there that are no longer valid, no longer necessary, or could be written in a better. I actually gave you, this is what we published from the vendor, because this is part of the test. This is actually your sample examination. So, that's part of the RFP. You would say, we want 250 questions. We want 150 questions. We want to test them on 50 questions now, as opposed to testing them on 30 questions. You have all of that type of control. You can even change your existing if you wanted more questions.
And those are all specs that can be put in the RFP. Right.
Correct.
Yeah. And I actually think in some of our exams, they don't actually, the number of questions is left to the vendor, insofar as it's the vendor's job to generate, again, a psychometrically valid, difficult to defraud exam. That number of questions, I mean, it could be set at a minimum, but I'm not sure that's even necessary as such, because I think, these sorts of vendors are, I mean, you put in there that they have to generate a bank of questions that's sufficient to run the exam, and I think you're generally.
And if I could interject, for the first round, if we went this round, and right now we're giving 30 questions, am I correct? On the
Yes.
state exam? Okay. So if we thought, we're going to work on this database and we're going to clean up those we don't like, remember that a lot of the essay ones would need to become multiple choice, so that we've got the different methods that the technology allows us to come up with the right answer. But even if we dropped it to 25, that might significantly give us a bigger pool, so that applicants can take it again and the person next to you doesn't have, and we're not as rushed with more questions being generated. It's something to think about.
You have a relationship, which the vendors clearly know, of the questions and the amount of time that the questions take, because the key to the whole process is seat time. How long is that person going to be sitting in front of that computer? Because that's what they're ultimately charging for, even though all the other background stuff feeds into that particular cost. And in that process, you have additional time that has to be allocated for upfront tutorial. Some people ask post questions. How'd you like the exam? How'd you like the process, etc. for knowledge. So I mean, you have to analyze. You have to analyze your questions to know how long they take. You have to analyze how many questions you want, because you're looking at a specific seat time. And you have to look at what the vendor deems as necessary in order for, in other words, you can't just go in, check in, and sit down in front of a computer and test question 1 is in front of you, and you're expected to know how to operate it. You have to have a tutorial to be able to get there. You got to at least know what you're doing, whether you're using one screen or 2 screens or whatever it is. So there's factors. I think we can get somewhat generic, and maybe I'm dealing a little bit more specific if we go that way. But there's a lot of factors to this equation that can't be broad brushed.
Those the things you're speaking of, how they bring people in, what information they collect, taking the photograph, all of those things. Those are more company policies than policies, and they build that into, and they actually produce. So this and another little sheet is what is produced by your current vendor on your website. The larger vendors produce a very comprehensive bulletin, is what we call them, and that's where we direct our licensees when they're ready to test, and those who are thinking about pursuing professions, so that they see what they're getting into and how that's going to work. it's a very standardized, this is what you can expect process. So we don't involve ourselves in that portion of their process.
And part of the RFP does talk about that document so that it's accessible to the person in Kentucky thinking of moving here and so forth. So it references the books that they're going to be using. All of it would be, so in their RFP, they're going to list that they're providing that document. And then that document is a living, breathing document. However, once you set your questions and they stay still, that document is fixed. When we meet again, let's say in our RFP we put that we'll meet every 3 years. Maybe we don't need to meet every 2 years. Maybe in the beginning we realize we have to meet every year until we get a bigger base. Whatever we put, then at that point that document's tweaked. That bulletin is updated because maybe there's a revision to a book, or maybe, you know, the structure of the percentage of questions from each category, how many are map based. All that is in that bulletin. So they would put that together.
Law changes, rule changes,
Right.
those necessitate going back to the vendor and having things refined, which that's, again, part of the contract with them, that's in there, that update happens on a schedule, or as that would be an on-demand. That would necessitate a change in order to ensure that the test is with the current laws and rules, which we tell them that is what they're being tested on. So
We've got a lot going on here from a lot of different angles on this topic. I'm going to, at the request of one of the board members here, and with all due respect to Ms. Whaley and Mr. Driver, we're going to ask for a 10-minute recess here. Just kind of take a quick time out. We'll come back in 10 minutes and pick up where we left off.
Great. Thank you.
Man, I didn't know we were going into all this. I want to welcome everybody back from a quick break there. I certainly appreciate the patience of both members of the board and our audience here of taking a little time out there for us. Okay, picking up where we left off, Ms. Whaley, of course, we had gone into some pretty lengthy discussion, possibly even on some tangents that we didn't know were coming about, but I think it was all positive and certainly trying and clarify what is a lot of unknowns, kind of treading into some new waters here. But water that I think we're going to have to eventually get to, and I certainly want to thank you for all the time and effort, obviously, that you put into this, and I think actually it might just be a precursor to all the effort that's going to be coming your way as well, not only on your part, but certainly all of the staff and the board as well.
we want to do all we can to assist our boards in doing their job.
You're certainly
Serving the customers and our licensees and our applicants. So.
certainly doing a fine job, and I know sometimes myself especially, but other members of the board would probably admit that we can be a little stubborn and slow sometimes and need a little prodding and convincing, and I think maybe you've certainly done your job in helping us that way. Certainly want to thank you for that.
Mr. Chairman, if I may, I would like to make a motion that to kind of help get this pointed, and we've had a lot of very good discussion back and forth, but I'd like to make a motion that we begin to work on the language that's necessary for an on-demand contract. That way Kimberly can be armed with what she needs, and this can move forward. And we'll let that process run its course and see what the end result is. But I'd like to make a motion we go that way.
All right, we have a motion on the floor. Is there a second?
Second.
All right. Before we go to a voice vote, is there any further discussion on this?
No, I don't think so. I think that we got to be headed that way sooner or later, so you might as well get started.
Ms. Whaley, I just want to make sure that the motion that was stated there by Tim and seconded, is that compatible with the direction that you're looking for from this board to proceed with where you need to be?
Yes, sir. I'll have just a couple of follow-up questions after
Absolutely.
that will be minor technical things, but that's probably the biggest portion of the motion.
Very good.
I don't know if you want to talk about those quick few things as part of the motion. It's more about number of questions.
Yeah, let's leave that to the semantics of once we decide we want to use that format, if that's okay.
No, that's perfect. Either way,
Okay.
I just wanted to give you your options.
Very good. Thank you. Anything further from Ms. Whaley or anyone else? We're good here? Okay, so we do have a motion second on the floor. We had discussion with a voice vote. All in favor, say aye.
Aye.
Any opposed, say nay. All right, the ayes have it. All right, Ms. Whaley, I hope we've given you some sense of direction. I'm sorry it was lengthy on our part, but I'm sure we all understand this is new waters for all of us.
No,
and certainly the unknowns raise a lot of questions.
I think there are some unknowns, but I think, we have a track record here in our department with this type of testing, so I guys feel you're in good hands, especially with Roxana as your executive director. She's navigated this before, so.
Certainly have full confidence in everyone on the staff, Roxana included especially, and believe me, it's not y'all. It's not y'all that's holding this back. I think I could say that it's certainly the members of the board here that they're just, but it is, it's new to us, but we understand we need to be there, and y'all are certainly pushing and prodding us in the right direction, I think, and certainly hope to be on the forefront of many of the states, and certainly get to where we need to be. And I certainly want to thank you, and of course Michael as well, for his time.
If we could just do a couple little housekeeping things that will allow us to, really get to that point. And as Michael said, I believe the board expressed, a desire to see sort of the final scope, and we will work out, along with legal counsel, the best way to do that, whether that be an email to each of you letting you communicate with Roxana and legal, or if it's like a conference call or something to that nature. So we'll work out those things. But the type of question, and this may be, Mr. Lingerfeld, I may need to engage you afterwards to, you're an expert in the type of question with the plat and how to correctly state what that is, because that is, super specific to the industry. But there is the desire, currently you have 30 questions. That's what your current contract is written, 30 questions. Do we want to stay at the 30 questions, which includes the multiple choice, and then Mr. Lingerfeld, the name of the drag and drop question?
Innovative items.
Okay, if you want a certain number of innovative questions as part of that, just so that we have.
I just do not like the 100% multiple choice because I feel like, and I think the testing vendor would agree, that I feel like that limits their ability in today's world to utilize their expertise in the testing that they have the ability to do.
And I completely agree with that. I just didn't want to oversell their capabilities and
Right.
not knowing the exact terminology. So
Right. In other words,
absolutely.
we're talking about a 4 to 5 year contract here. I want language that is palatable to this type of vendor, such that they don't have restrictions to something that we've created because we've came from an antiquated system.
Absolutely, and that, again, will be part of your,
Okay.
when you have your meetings with the vendor. So it's currently 30 questions with
2 additional.
2 additional, which I believe actually is in totality part of the 30, the way it reads. So do you want to stay at 30? Do you want to go up? Or the 30 plus the 2?
I would just, on the face of the question, say, yes, let's stick with the way it is. In terms of number of questions, I'm in favor of, if we can use those innovative questions to require the applicant to generate a plat, written descriptions, things like that. I'd like to try and keep it much like the format that it currently is. Just, switched over to computer-based. But obviously this is going to evolve. I would expect the vendor to have suggestions, ask questions of us, and I certainly would like the liberty to be able to, not recreate the wheel, but certainly maybe add some spokes to it if we need to.
Absolutely. I just want to make sure when we do the RFP, we do include the innovative type questions, and they probably will come back and ask what those are, because that's part of the process, is they can ask us questions. So be showing them. Okay, so we'll stick with that.
Actually, if you want to clarify that, they're really called alternative item type. Real exact in the vendor language.
Probably provide some framing with that as well. By rule, it is 70%, so that will stand unless your rule changes. And then as far as the exam review, we will include the broad language, which we currently utilize in, say, our cosmetology and barber contract, which allows one board member at a time to interact with the vendor. So we'll go with that broad language if everyone is comfortable with that. Okay. I think we have what we need to. Yes, sir.
On the fee, are we going to, like Mr. Drivers talked about?
with allowing
through.
them
Pass through.
you have the option of the no-cost contract, or you have the option to pay for development with the set fee. If you want to get away from this set fee, we will need to, as part of your rule package, alter that.
I think it's kind of a mixed bag, and Miss Roxanne can speak to that. I think that because of such a dramatic change from where we've been to where we hope to go, I think that we have to look at, we as a board and our finances have to look at some supplementation of the development of the examination. And then I think that based on what Mr. Driver said, I think it's practical to look at a pass-through fee to the applicant so that it's basically no cost. That's what I heard said, and please correct me if I misstate that.
No, I believe what you're saying is we will allocate some number of dollars for development. Then are you allowing them to set the fee, or you're going to say the fee will be $150?
No, we're allowing them to
set
set
the
the fee, so it's a no cost to the board. It's a pass-through, as
Okay.
Mr. Driver discussed. Only thing is, we're supplementing up front the initial blow.
So the actual
To a point, and I guess I would have to ask Ms. Roxanne if she could kind of determine a number from our budget so that we kind of have let's say we have a target number or a ceiling or something so that the vendor understands that the board is going, or the board department, et cetera, is going to contribute up to X amount of dollars for this type of stuff, for the development.
Absolutely. So you will do the exam portion as a no cost, but the contract itself would no longer be a no cost because you will have those development dollars. But absolutely, we can
Okay.
write that.
However you need to write that up.
I want to interrupt here. So the rules that we're going to discuss later when we do legal, I do have a suggested change of allowing the vendor to set the fee. But right now, the rules do state that the fee is $150 for the exam. So even though we're trying to transition away from that, like, that won't happen for several months. So I don't know, is there a way to, I feel like we have to accommodate that we're trying to move that way, but at the same time, I don't know that we can change the price of the exam until our rules match it.
Well, I just wonder about that because that was a little different than what Mr. Driver described it as.
Right. I think potentially you could write year one as one way and year two as a different way.
Okay.
I can ask. We can work internally
Okay.
to figure out how to
Okay.
make that the timing of the rules
Okay.
versus the timing of the contract and which contract period, et
We
cetera.
I don't know that we're going to get all the answers to that particular rule today, Miss Laura, but we might. But if we don't, we could certainly, I don't like to use the word delay or hold that until we see how this process shakes out, and then that way they match.
The board's main concern, and correct me if I'm wrong, is, and I think we all agree that the soon-to-be licensee, that the applicant's not picking up a $1,500 exam fee.
Right.
And so with that in mind, if we do come up with the first year, it's going to be picked up with the board, which right now picks up the vast majority of the expense anyway. I think it can be built in there as such. And so we look at then it changing, and if maybe it isn't for the 5 years the first time, maybe it's just for 3 years, so we can reevaluate what that fee should be.
I think the biggest piece is you're getting that development, you're getting started down that road, you're engaging that expertise. So we can work out this little piece of it for something that is definitely keeping in mind staying completely applicant focused, customer focused, to ensure that we are not, unnecessary excessive expense in order to take the examination.
Okay, good. Any other details we need to work out there? Ms. Whaley, anything further?
I think that's it. I may have specific questions regarding the plat. Is there a board member who'd like to volunteer? If there were any questions.
Well done, Tim. Well done. We appreciate you stepping forward. That's benefits of being chairman.
Glad to always be of service.
I get to delegate.
That's voluntold, right?
Yes, absolutely.
Okay. Yes, because there may be specific questions. We want to ensure too that wording, because that is sort of a difference. Most of ours, again, the 100% multiple choice, most of ours are because they're not technical in nature. So this is actually exciting. This is new territory for us. So.
For all of us, yes, absolutely. All right, well, good. We're excited about it. We look forward certainly to getting that moving on down the road there. Okay, we good?
We are good. Thank
All right,
you
Ms.
guys
Whaley.
so much.
Thank you
Have
for
a
your time
wonderful
and
day.
Michael's time as well. Appreciate that much.
Thank you, Kimberly. This was awesome. It's very, very good. Thank you.
All right, Roxanne, I see Brian is back there. More business, Brian? Just hanging out? Okay. All right, I know our agenda has been jumping around here quite a bit. Is there any other business we need to move ahead to first? We want to pick up where we left off there?
Totally in your hands. We are
Okay.
fine to continue where you would like.
All right, well, I'm going to go back up to the top here with what we have not yet covered, and that was the education report. I think there may have been some materials handed out there as well as on the iPads here. I think I saw, yeah, there it is.
I have, Mr. Chairman, I have two questions about the educational report.
Yeah, go right ahead.
One is, I noticed that all of the courses already have CER numbers, and that's based on our advisory board, I assume's approval. However, I think we have final approval of whatever they do, if that's so stated correctly.
I believe that is correct, yes.
Well, there is a category on the end of page 2 and all of page 3 that I am greatly concerned about, because this category implies that this instructor is going to provide seat time for, see how many courses, 6, 9, 18 different courses. And the vast majority of these courses are 8 hours, and even one course is 12 hours. Well, as you well know, our structure of our continuing education, allows, 10-minute intervals and so forth, so, and breaks and lunch and so forth. So we're looking at an 8-hour course, taking 9, 10 hours, potentially. But my greater concern above and away from all of that is the fact that there seems to be some duplication here. And I would really want to review what this individual has. I mean, because I'm not the sharpest knife in the box, but 4-hour PDHs on horizontal curves, 4-hour PDHs on vertical curves, 8 hours on trigonometry. You're teaching a licensed professional about these topics, and those hours are, in my mind, appropriate to a yet-to-be licensee as opposed to a licensee. I think that's the paramount purpose of our continuing education, is that it be something that is beneficial to the licensee. I mean, the vast majority of all of these courses are entry-level training courses. That's my opinion, Mr. Chairman, but I would not vote in favor of those being approved, short of being able to review each and every individual course sheet that goes with each of those courses.
Well, I think, Tim, it is within our realm, if we have questions on any of the courses or several of the courses, to number one, we can disapprove them. Number two, we can request additional information from the applicant, or I think it's not too far off, if we wanted to, request the applicant come to the next meeting and explain each of the courses, if that's what we desire. I agree with your assessment. In fact, you took the words out of my mouth when I was reviewing these earlier. Looks like an awful high number of PDHs for pretty much entry-level courses just based on the surface of them. I think we've come across, was this an applicant that has applied before and we had similar responses, I believe?
Yes, sir.
In fact, I think we, I'm just going off memory here, I think we selectively reduced the number of PDHs for some of the courses in prior meetings. Don't hold me to that, but I think that's what we did.
That is correct, Mr. Chairman.
And I also think our prior request to doing that was to get additional information from the applicant. And I believe at the following meeting, we received that information, and then we assessed different PDHs based on our opinions of it, which ultimately is what gets approved here. So we have a couple of options here with these. I believe these were all submitted by Mr. Thompson, I believe, if those are correct, the ones that you're speaking of. But I would think, at the very least, just kind of in step with what our previous actions were, to not approve these selected courses at the moment, but rather get back with Mr. Thompson, request specific information on each of the courses, justifying the amount of PDHs, and then and make a ruling on it at that time. If there's any agreement or objection to that, I'd certainly entertain it.
I certainly concur with your analysis, Mr. Chairman, and I'll make a motion that we approve the educational courses with the amendment that any course that's provided before us, submitted by William A. Thompson, have additional information submitted to this board for the board's direct review prior to any approval. And my guess, one other thing, well, let me finish with the motion, then we'll discuss it. Go
All right,
ahead.
so we have a motion on the floor. I do need a second before we can discuss it.
He hadn't finished the motion yet.
No, I'm done. No, I'm done.
Oh, yeah.
I'm done, then we'll discuss.
Motion made. I do need a second.
I'm ready to second.
All right, so second.
I do want to discuss a little bit on it.
Yeah, please do.
I think that second course down there, that S3, I'm not sure what that has to do other than dendrology. Dendrology, I think, is paramount of importance to the surveyor, but I'm not sure that geocaching has anything to do with surveying.
Well, I think with, based on the motion that was made here, requesting additional information, we need to give him the opportunity to justify. And I think requesting information would do just that.
Particularly for 8 hours.
Yes. Mr. Chairman, I'd like to ask Ms. Roxanna, if I could, about when the staff sends this gentleman a letter, if it will say in that letter that these courses are not approved and may not be taught until such time that the board has acted properly on them.
Absolutely. I was going to
Because what I
read.
don't want to happen is, I don't want
Yeah.
this gentleman to feel like his courses are approved, and he starts scheduling them at Thanksgiving or something, and starts teaching them, and we as a board have not approved them. Then we have registrants that are taking unapproved courses.
Absolutely, absolutely. So soon after the meeting, we start on the letters that need to be generated. He would be getting a letter saying that at this time the board did not approve any of the courses submitted, and they all happen to be 8-hour courses. So that's makes it, well, no, there are a few that are not, but all of them at this point have been put on hold, if you will, until additional information is requested. And am I also correct that you would like him to be in person at the next meeting, which is January, or just the additional material?
I think for now, and correct me if I'm wrong, if it was in your motion, I missed it, we're just requesting additional information specific to each of the courses that he's seeking approval for. That's what we're looking for.
And upon approval or denial of those, we will send him a letter after the January meeting letting him know what can then continue. Perfect. Understood. Thank you.
That's what he has to submit for us.
Yeah.
In other words, he can't just tell us it's about A, B, C, and D. He's also got to justify why he requires that many hours to teach that.
Okay, that's what I want.
Yeah.
Okay, so if that could be addressed in the letter as well.
Absolutely.
Yeah, okay, very good. All right, so we do have a motion, a second. We've had further discussion. Is there anything else we need to discuss before we take a vote on this? All right, hearing no further discussion, with a voice vote, all in favor say aye.
Aye.
And opposed say nay. All right, the motion is approved. Okay, so I guess actually, did that motion include approval of the, I guess it did, approval of the education report excluding Mr. Thompson's, isn't that right?
Correct,
Okay,
yes.
very good. Okay, so I think that covers everything we need on the education report. Very good. Okay, moving on to the next item is the director's report with legislative and newsletter updates. You want to
Thank
address
you.
that?
Yes, absolutely. So the first thing I want to touch on, we are on page 14 on your iPads, is kind of the new look of the financial information we're being given. So I'll walk us all through it because it's a new visual to all of us. The idea with finance, and I think I brought it up at the last meeting we had, is to use the current licensees, our computer-based system that we have with the database, and a lot of the cost backs now charge them back to us, kind of. It's not that final entry, but it's a really good idea based on everything we're doing each month so that we're not surprised at the end of the year with that cost back. So consequently, there may be some months where we look like we're not doing well financially, but keep that in mind that we haven't gotten a big pool of renewals and what have you. So I don't think we have any reason to be concerned with the finances, but this will give you a good visual of what each month is, and we've got July and August already spent there. And so you've got your revenues there as well as then the list of expenses. This is kind of what it will look like. If the board doesn't have any problem with it, I'm going to take it exactly as finance is presenting it to us. We do not have the very, very final numbers for the 15 to 16 year end. We were told that there will be an entry that includes old bad checks. And so I'm waiting on that final number, but that's to every board. So depending, some boards picked up more than others. So we will have that final piece that I hope to present then at the next meeting in January. And of course, those books will have been closed. And then this is kind of how we'll look moving forward. You've got at the bottom the 2016 figures per year, and then the expenditures as well. So that's kind of our financial piece. Before we go on to legal and any updates that Laura has, I thought I would take this time to refer back to some of our items left on hold after the October 5th meeting. One of them that we discussed had to do with the plaques handed out, the certificates handed out to our new individuals. So I've handed everyone a visual to kind of have and hold that we can take a look at. And we want to start almost immediately to get caught up with those individuals that we owe this certificate to. So our office is going to run a report that goes back to whenever they didn't print, we've taken in the money. This current version can be tweaked if you all decide we need 3 or 4 people to sign. We can talk about that right now, or we only need 2, or we only need the chair. That is completely at your decision. So those are the things that definitely can be changed. The font if we wanted to get creative. But if we're ready to get these out and we approve these today for the January meeting, I will have them printed and ready for signatures and out in the mail, which is what I'd love to do, and I think our people that have been waiting would love to see happen. So, and then on an ongoing every month, we can just automatically be in this process, and then for each meeting, you'll have maybe 2 months to sign. So we'll be back on track, and I apologize that these are behind. So we're going to get them caught up. Any questions about, I know we only have one original floating. You're welcome to compare them. The paper size is going to change slightly. I like the stock of this paper. I think it's a standard size for framing, but this is your colleagues. I want you to be happy with it.
I'll tell you, I'm very impressed with the new format there. You had asked some questions there about some possible changes. I'm comfortable with the font. Obviously, there's some wording in there that needs to be changed based
Absolutely.
From the example we've discussed that already.
Yeah.
I think the only thing that I would suggest is in keeping in conformance with the previous certificates that were issued out, where all 4 members of the board had room for signature.
Perfect.
Which I think is ideal. I mean,
Perfect.
Each one of us, signing each of that, I think is a great idea. That was the first thing that caught my eye. Galen, did you see anything? Anybody else?
No, I
Tim?
think you need to have the 4.
And we've got the chair. How else do we want the others? We want vice chair, secretary. How else did the previous, and are we happy with that look, or just members?
I think board member might be fine.
Perfect.
I think
Perfect.
that'd be fine.
Okay.
We also usually put the board seal on it. That's what goes here. It's not on this particular one, but that's what goes there, is the board seal. And the other question that I would have, Ms. Roxanne, is in the interest of efficiency, would it be appropriate to have our signatures as a stamp so that your staff could, once that person is approved, could actually stamp that on there in the appropriate line and then send it on out? And the licensee then would not have to wait another, 2 months or something so that we show up and sign it. That's just a question.
So my gut, having worked with the stamps and the bulk signatures, at the end they kind of do look like a stamp. So remembering, and I agree to you. So it is efficient, but remembering the symbolic explanation you gave me, which I took to heart, I think our folks would prefer maybe waiting a little bit, because thank goodness we meet. It's not just twice a year or 3 times. So if the board's okay, we'll do it as soon as everyone gets in and sign them and get them out. But I think symbolically that, blue pen or whatever we choose and you all signing them may be worth the additional delay. But at the end of the day, we can do the stamp.
Just a question.
I agree. I think it gives a little more personal.
Okay,
Yeah,
we're good.
Just a question.
We're good. Okay. Tell me a little bit, so about the seal. Would someone be able to send me the seal that we had? Do you know? I wonder if we probably have. Oh, good.
You have
Yay.
it. It's a
You have
gold seal, and it's probably on a
Fantastic.
roll, and you just peel it off and put it right on there.
Perfect. Okay.
As a matter of fact, you probably could give it to the printer, and they might even be able to print
That's
it
what
on
I'm thinking. If the printer can have it
I don't
as a
know.
version of PDF,
Yeah.
they'll just add it in there. So that's
Yeah.
what we're going to shoot for.
it. Don't know that.
Okay. And you want it at the maybe corner over here? Is that okay? Fantastic. Anything else?
Yeah, I think format-wise, I think that should cover it. I just want to say thank you for picking up the ball on this and getting this issued.
Oh, my pleasure.
I know the
Thank
the
goodness
surveyors-
Cody brought it up. Yeah,
It is huge, yeah. It really is. It means a
Yeah.
lot.
that
And,
is fantastic.
I feel personally bad that the ball was dropped at some point. I mean, there was things that happened, but for those surveyors that have been waiting on this is huge. So thank you so much.
I think we can come back maybe toward the end to the newsletter and discuss it. So if the board's okay, we will go on with the legal report and turn it over to Laura.
No legislative update of any sort? Ms. Roxanne?
No, none at all. I think what I'm going to do, because I find it confusing to me, and maybe I'm not alone, I'm going to take that off of our agendas other than during the session when the legislation is going on and we then from January all the way to April or May have to cover and we want to discuss heavily. But otherwise, generally speaking, unless 1 month or so the attorney wants the board's opinion of things that we would like the legislators to consider, that would be the only other time we'll really have something otherwise.
A lengthy meeting.
Yes, yes, so we are good. I'm going to pull it off. Thank you.
Okay.
All right, Miss Laura.
Good morning.
Good morning.
I guess I will just begin reading and you can interact with any questions you have, and then we can discuss each case after I read it into the record. Okay, case number 201602953. This complaint was filed by a consumer who alleges that the respondent did not send them a survey that they had paid for. The respondent allegedly will not refund the fees and has not responded to phone calls. The complainant had called the respondent, and he and his employee came to her house to take photos. They told her that she would have the survey in 1 week's time. The complaint gave the respondent a check for $325. This occurred in July of 2015. The complainant alleges that she called the respondent many times in the following months, and each time he said the survey was on its way, but said there were complications. The survey never came in the mail. Complainant says she no longer needs the survey. She provided a copy of the check written to the surveying company. She attempted to cancel the check after months of not receiving the survey, but found it had been cashed in July of 2015. She states she believes she was taken advantage of because of her disabled status. In response to this complaint, the respondent claims that he obtained a copy of the latest deed of record for the complainant's property with a description based upon a survey performed on June 14, 1995. This indicated to the respondent that he would be doing a retracement survey of the property. This same description had been carried forward in conveyances since 1995. On or about July 3, 2015, the respondent and his rodman proceeded to perform the field work on the property. Having plotted the deed description, they were able to find iron pins or pipes at the four corners, as described in the deed description of 95. Field measurements between the iron pins or pipes did not match exactly the distances called for in the 95 deed description, but followed the lines of possession and fences. The discrepancies can be attributed to precision differences in survey methods and or equipment, or probable disturbances of the corners in the 20 years since the survey had been completed. The respondent explains that the 325 was for the field work. A sketch of the survey was not part of the original agreement or covered by the 325, only the field work. When asked for a survey, the respondent told the complainant that he would sketch the survey in the next couple of weeks as time permitted. As business increased, the respondent was unable to work on the survey. The survey has still not been sketched. Since this was separate from the original paid-for services, he did not prioritize it. He stated that he felt badly if he was not clear that the survey would be separate from the field work. He has offered to refund one half of the complainant's money if that would be suitable to the board. Going forward, the respondent says he will try to ensure the clients are clear about what services they are paying for on the front end. My recommendation would be to close this case with a letter of warning after confirming the respondent has refunded the one half of the paid fee that he offered.
Ms. Martin, I would have to query you on the statement of the respondent refunding one half of the paid fee. I don't know of anything in our rules that would give us the ability to make that direction to a respondent.
Normally I wouldn't say that, but this is a thing that he specifically offered. This isn't the kind of thing that we could direct him to do by statute, but consent orders are like settlement agreements. And if he's offering to do this, and I can confirm that that has happened, I would recommend at that point it's been worked out between the two of them to the best that it's probably going to get worked out, and that we could close with a letter of warning, basically just citing the fact that saying that the services that she was expecting were not part of this like original fee that she had paid. She clearly thought that they were. Regardless, he did tell her that he would get this survey to her, and it's more than a year later, and he never did.
Do we know if there was a contract agreement between the two? There's no mention of it here. It doesn't sound like there was, but it doesn't specifically
No,
say
I think
so.
it was verbal.
Just a verbal.
I
Okay.
don't. Yeah,
Okay.
nothing was provided to me, and I always ask them to give me any contracts that they have, and the way both of them described the scenario, both in the complaint and in the response, it appeared to be verbal.
I've got two issues with the recommendation on your part. In these two separate items. One is the letter of warning, and separately, but also included, is the request of refunding half the paid fee. I am uncomfortable as a board member here issuing something like this, and I want to take these individually. First of all, the letter of warning. I understand where you're going with that, and outside of the board here, I would be all for it. I just don't see where this board has jurisdiction on what I'm going to call "quote unquote" bad business. How he conducts his business is his business. How he performs or creates surveys within the standards that this board has jurisdiction over is our business. That's where we can step in. That's where we can step in. And the same thing with the refunding of the half of the paid fee. I'm all in agreement. He should, at very least, I think, pay half the fee, and the fact that he's offering it is great, and I certainly encourage him to do so in an effort to, quote-unquote, save face. I just am uncomfortable, and I need some guidance and education from your part as to, does the board really have jurisdiction in number one, issuing a consent order to refund half the fee, and number two, in a letter of warning, what are we warning against in this letter of warning? Yeah, it's bad business, and sure, it's poor customer service and all that. But I don't know what the board has jurisdiction over that we are warning the respondent here of.
So
is my question.
I'll start with the fee, and then I'll get to the letter.
Okay.
I don't recommend that we send a consent order requiring him to refund her. He has offered to do this, and my suggestion is that I'm going to contact him and say, we're going to close this with a letter of warning after you've done this thing that you've offered to do.
Okay.
That's it.
Okay.
If we're uncomfortable with that and you don't want to make the discipline contingent on him following through on this offer, then we don't have to do that. I can just tell him the board thinks that's a really good idea, but that's a personal business decision.
Kind of leaning that way.
Okay.
Personally, my decision is that way. But go ahead, continue.
Secondly, the warning was that it appears to me, even from his own response, even if he didn't contract with her, it seems as though he did offer to do this survey for her, and then he didn't do it. I mean, isn't there an issue with him like offering to take on work that he doesn't have the ability to do? I'm pretty sure that's even in our rules.
I think maybe in an ethics type way, it certainly is very poor on the face of it. From just what I know right here, it's very poor. I just don't know that we have the onus upon us to issue a letter of warning for bad customer service and poor ethics such as that without getting specific. I mean, if there's somewhere in our rules that itemize that, if you offer the service and you have to perform it to everything that you promised to do and for the fees that are paid, et cetera, then by all means. I don't want to get into the position of this board dictating their business. I want to be in the business. I want to be dictating what the rules say that we have jurisdiction over. Bad business is their business. Rules and the application of those rules for surveying is where we step in. Does that? I don't know if I think I'm trying to say too much by trying to keep it short. Galen, do you have any thoughts on this? Betsy?
Well, my thought, other than I think he should have refunded the whole amount, but that's just
Again,
because he hasn't
business.
provided what she asked for, and I thought that if he's going to do the survey and he quoted her a fee and he hasn't done that, I think that whatever we tell him, he needs to provide that survey and do if the thing is step up to the plate and pay one half of the fee back, he needs to also hand her that survey at the time he hands her that.
I don't think she would wants the survey anymore.
I saw that she said it's not necessary anymore. I read that in there, but I still think that that's a requirement on his part because he didn't live up to it.
So, if I can interject very quickly to the point that you were making, if we were to go forward on someone's bad business practices, the only jurisdiction we have to do it is in our rules. It's under misconduct, and basically, it's only if we think that the behavior rises to the level of fraudulent or dishonest behavior. If you think that this is dishonest behavior, then yes, we can issue a letter of warning. If you don't think that this is dishonest behavior, then no, we don't have the authority to issue a letter of warning.
If I could just expand on that, again, just on the face of it, the dishonest behavior in terms of business or in terms of the survey that was done, because I don't see anywhere in here that he performed a bad survey. That's not what I'm seeing. I see that he performed poor business and poor customer service. His misconduct or his dishonesty, if there was any, would be on a business aspect of it, not on a surveying aspect of it. Yeah. And I don't want to overstep the bounds of what this board is to regulate. Does that? I hope I'm making myself clear, Tim.
Yeah. If I may, many times I get telephone calls from prospective clients that ask to have their property surveyed. Now, just because they ask me to survey their property does not tell me truly what they want. My dialogue generally is, are you wanting your corners found? Are you wanting your property line staked? Do you require a plat of what I'm providing for you? Because our statute does not require the surveyor to provide a plat, a sketch, or a document to the client. And because of that is why I ask those questions. Yet I know many surveyors that don't ask those questions from a business standpoint. You know, think about it this way. The respondent gets a telephone call from the complainant. The complainant says, can you come to my property at 123 Blue Lane and survey my property? Yes, ma'am, I can. How much will that cost me to survey my property? $325 in this example. Okay, when can you be there? I'll be there next Tuesday. Okay? All right, we have a verbal contract now. And the inherent understanding of that verbal contract is I'm going to go survey this lady's property, which to me, more often than not, means I'm going to go find her property corners, mark them so that she can identify with them where they are on the ground, and I'm going to send her an invoice, $325. Now she picks the phone up and calls me and she says, thank you very much, Mr. Respondent, for doing my survey, but where is my map? And I look to her and I say, ma'am, when we made this agreement, there was nothing mentioned either on your part or my part about me providing a map, a plat, or a sketch. And she said, well, I've got to have one. Well, my dialogue at that point in time would be, well, I will be glad to provide you that plat, but it will cost you another $325 if that's what the fee is. And then she's very upset, and she goes to the board website, she gets a complaint form, she sends a complaint in, it goes through the process, and here we are.
You don't think the average consumer would make the assumption that when they're paying for a survey of their property that they're not going to get some sort of written?
No, ma'am. No, ma'am. That's why.
Okay. I mean, I know that you're talking from the surveyor perspective, but I think but I get what you're saying. I shouldn't even argue with you on that. My point is that in his response to me, he said, I told her I would get her the survey as time permitted, but likely within the next few weeks. It's been more than a year, and he never got it to her.
Well, in my mind, that's a verbal contractual agreement between him and her. And I don't see, as Jay said in the beginning of the discussion, I don't see that the surveyor has done anything wrong relative to the survey. But yes, he has had poor communication and poor business skills with this client and maybe many others. I don't know. But I don't see that this board, short of, as you mentioned, incompetence, has any way of doing any kind of discipline to this respondent because he didn't communicate. I mean, now, there's a statement in there in our rules of professional conduct about you should always make truthful and honest statements. And clearly the respondent has replied and said, yeah, I did tell the lady I was going to do that, and I just hadn't got around to it. So, I mean, I think he has been honest and truthful. Just as she has been honest and truthful. And it's a very unfortunate and, in my mind, somewhat unprofessional situation for that surveyor to have done. Yet I do not think it rises to the cause for you as our board attorney to send them a letter of some type of something that goes in disciplinary in their file.
Okay, well, we can just close it, and I cannot send them any letter. I just want to be clear about your jurisdiction. You do have jurisdiction to determine what misconduct is. It even says in your rules. If you don't think that that encompasses their interactions with the consumers beyond the finished product, like that, the truthfulness of the plat, that is the board's decision. But I do think that in limited circumstances that you could decide what your jurisdiction is, or, well, not you can't decide. Sorry, I misstated that. You can decide if your jurisdiction on misconduct covers certain business situations. If you don't think that this rises to that level, then we can just close it, and I cannot issue any sort of letter or anything.
I think this goes back to a lot of cases that we've heard over the years here. The value of having a contract with the client. Although it's not mandated, some states do mandate a written contract, and I think it's something this board should address at some point. Current value, and this is a prime example of it, of what the client can expect, detailed out in the contract, even if it's just a one-page, simple contract, fill in the name and the expense, et cetera, et cetera. But we don't have that here, so let's deal with what we got. I would add, well, I agree that no formal letter of warning should go as a disciplinary action in this case, my opinion. I would request that we do respond back with a letter from this board stating such. We're not addressing any kind of letter of warning. However, we would request that in future dealings with clients, the suggestion of contracts be included, and that perhaps better communication skills with the clients so that they have a clear understanding on both sides of what they can expect from his services.
Or like a letter of instruction. Am I reading that?
Whatever it is,
right?
I don't
Yeah.
want it to be a disciplinary action or anything that goes in his
I got
folder.
you.
It's just a letter of correspondence.
Could it use language such as, and I'm just going to say it this way, it doesn't mean it's the right way. The board's desire is that you will consummate the situation with your client or something of that nature, as you've indicated, or something like that. Because
off the top of my head, if I were drafting this, I would probably say this is not any formal disciplinary action. How you handle this is a business decision for you. Encourage you, although we're not demanding, but we would encourage that in the future you communicate with your clients. This is more of an encouragement than anything else.
I don't have any issue with that. I think that's a
Okay.
very palatable way of addressing the situation, and also letting the respondent know that, yes, the board did take time, we paid attention, and we considered, and we just hope that you'll do what you should do.
I don't know how long he's been in practice, but I will say again, the client never tells you everything. So when on the outset of all of this, it's incumbent upon the surveyor to determine on the front end, when they're making a verbal contract or a written contract, that they get from the client everything that the client thinks they need. And here I see, I don't think that happened. And it just went, did what I think he was instructed to do, and that was survey the property. And he found that, hey, distances didn't match and what have you. Okay, that's fine. I think that's incumbent upon all of us that we go out and do that. And we're going to find these things that they're.
Betsy, anything you want to add?
No, I think you all have covered it.
Okay, very good.
Okay, I'll move on to Kate.
But I think we need a motion to.
We can motion at the end to
Oh, you
accept
gonna
the
do it at
legal
the end?
report with the
Okay,
amendments.
Okay, it's fine.
So case 2, number 20160322621. A complaint was filed alleging a boundary dispute. The respondent created a survey of the land that is adjacent to the complainant's property in 2009. In 2013, the complainant bought his adjacent parcel. He had a survey conducted of his land that disputes the survey that the respondent had filed with the county clerk in 2009. The heart of the dispute appears to rely on whether a called-for land monument in the complainant's deed was properly addressed in the 2009 survey. The respondent claims that the 2013 survey does not reference his on-file survey and that this complaint was filed because he refuses to alter his survey or testify that his survey was incorrect. The survey that was provided by the complainant was unreadable to our expert reviewer. The respondent has been contacted on 3 separate occasions for a copy of the survey for our reviewer to look at. To date, he has not sent in the survey. He has expressed that he doesn't think he should have to, but said he would send it in the next few days. So I wrote, at best, this will arrive the day before the board meeting. I still have not received it. He told me he would send it, but I still haven't received it. He was first asked to send a copy of his survey to the department on June 14th of 2016. So I've recommended that we issue a letter of warning concerning cooperation with the board. They are required to cooperate with an investigation. I think that the central issue is probably more of a boundary dispute between the landowners, but he every time says he'll send it, says he doesn't think he should have to, but he will send it. But it's been several months. He still hasn't sent it.
Okay, it seems like we really have two separate issues here. Number one is the issue that they have with the surveys and some disputed property lines, et cetera, et cetera. That's one issue, but I don't think that's what's being addressed here, nor is being asked to be addressed. What is being needs to be addressed here is the fact that although it's been requested on numerous times, they're not providing a copy of the survey for the reviewer's review. Okay, so that's kind of a separate issue from the whole boundary dispute.
Right, because of course the complaint wasn't about that.
Right.
But in the end, here we are. I can't
Continue on with the investigation of the complaint. Okay, so it is holding back the investigation by the reviewer to come to an opinion. Okay, all right.
And I struggled with this complaint because it's not as if he's refused flat out to send it. He just hasn't. Even though he has responded and said
to this point
in so many words he'll get to it, he hasn't.
Yeah.
So I don't know that I can hold this complaint on the hopes that he'll eventually send it, because I don't know that he will.
At this point, has the request for the survey just been by telephone? Has it been by formal letter?
There was a formal letter by our staff back in June 2014, and then I've also emailed him twice at least, and then the last email he said, all right, I'll do it. And that should have, if he had done it the day he told me he was going to do it, it should have arrived at least by yesterday. And like I said, I still don't have it.
Is it beyond our purview of this board to direct him to reply to a letter to send a copy of the survey because it's holding back an investigation? I would certainly think so. I would hope so. I mean, we have a complaint that needs to be addressed, and it's being held back because he just won't or hasn't sent the survey yet. Perhaps we should send a stern letter to him, directing him from this board, directing him to send a copy of the survey. Any thoughts on that?
Well, Mr. Chairman, I concur with what you said. However, I want to put a little more teeth to it. My arithmetic's right. We're talking about starting in June, and today seems to be October. So that seems to be more than significant amount of time for a respondent to comply with a letter from our legal department. It's my opinion that we should issue a civil penalty as allowed by our penalties, and also in that consent order that the plat be sent in. And then one further thing is that should this case go to a court of competent jurisdiction, and whatever the findings are, this board would be able to review whether or not the surveyor had other violations after a court of competent jurisdiction makes its ruling. Now, I realize that's a whole lot of teeth, but I'm not I'm not happy any time that a registrant fails to respond in a reasonably timely manner to this board or any other board they're registered by.
What if we were to send him a consent order that requires that he send us the survey by a certain time or a date, and then if he doesn't comply, then a civil penalty will.
Right on where I'm
And
going.
and then also require that we be kept updated on any outside litigation so that we can review the findings.
But I don't want to close this on that consent order because he complies by simply sending the plat. Because it appears face up that there's a problem from the writings that we are presented, that you read to us today, and it brings question to my mind that he's holding something back because he hadn't sent that plat in.
So I'm expecting him to send a copy of the survey. I'll give him
Legible copy.
a legible copy of the survey.
I believe the first one was unreadable.
Well, in fairness, the first one was from the complainant.
Oh, is it? Okay, my bad. Pardon me.
So I'll get a couple of weeks, maybe at least a month's time, and if he doesn't, then a civil penalty is going to be issued, is what I'll say. What would be an appropriate civil penalty for not complying with this request?
I read our penalties correct. I think $1,000. I think we can go to $1,000 if I read the penalties right. But you need
can
to
go to $1,000.
You need to verify that. But I would recommend $1,000.
No question.
I mean, we need to get people's attention if they're not going to comply.
I would suggest that it be sent by registered mail.
Yes.
Not standard mail. Both the letter to him and his response back with the plat, if that makes sense. It was. I knew it would be.
Okay. Okay. If I find out that there is outside litigation, I'll also, in the letter that I sent to him, I will also direct him to inform us of any outside litigation involving this property. Okay. Okay. Number 3. Case number 201-603-9211. A complaint was filed against the respondent alleging that multiple errors were present in a survey conducted by the respondent. The complainant was having a boundary dispute with neighbors and contracted with the respondent to conduct a survey. The complainant alleges they saw the respondent chatting with the neighbors on several occasions for lengthy periods of time. At one point, the complainant was in a heated discussion with the neighbors, and the respondent told the complainant to go back to her little cabin and drink her coffee. After receiving the survey, the complainant had a real estate property developer look at the survey as well as another land surveyor, and the complainant alleges that both of these people said the survey was full of errors. The complainant also believes that the respondent held clandestine meetings with the neighbors at a nearby barbershop to show them the survey before giving the completed survey to the complainant. In response, the respondent says he only spent a few minutes speaking with the neighbors because he was explaining why he was there and what he was doing. At one point, he said he did tell the complainant to go back to her cabin because they were cursing at the neighbors while he was trying to work. He completely denies any clandestine meetings. The neighbors did call asking him for a copy of the survey. He says he told the neighbors he couldn't give them the survey, but that once the complainant filed the survey with the Registrar of Deeds, it would be a public record and they could obtain a copy. The expert reviewer that looked at the survey, who had told the expert reviewer who looked at I miswrote that. Our expert reviewer looked at the survey, and then he looked at the survey that the complainant had said was full of errors. The surveyor's license was expired, so our reviewer gave no credence to those concerns. After reviewing the survey and the deed, the expert reviewer said he found no errors in the survey. I'm going to restate that because I wrote it confusingly, and I apologize. Our expert reviewer asked for the name of the surveyor who this complainant alleged said the survey was full of errors. That person's license has been expired for some time, so he said he didn't really want to give any credence to those concerns, and then said he found no errors on his own in the survey and that it appears to just be a boundary dispute. My recommendation is that we close this case.
Yeah, I think it's pretty straightforward. Obviously, we've got a lot of he said, she said, back and forth in there with some differences.
In fairness, you
and
guys
some
told me you wanted a
confrontations.
lot of facts at my very first
You
board
did,
meeting.
and you did a great job. You did a great job of it.
You did say that to me.
Great job. Great job. We appreciate it.
But yeah, I mean, it all wraps itself in at the very last sentence. It sounds like the reviewer did get a copy of the survey and the deed and found no errors in the survey, which is exactly where our jurisdiction is. I would have to personally agree with your recommendation to close.
I have a question, Mr. Chairman, please.
Go right ahead.
Date of survey, date of expiration of license.
Oh, on the legal report for the respondents? Okay.
Because if the date of survey is after the respondent's date of expiration, we got a problem. If it's not, we don't. Would you agree with that?
I want to clarify who had the expired license. Not the surveyor who conducted the survey. That's not who has the expired license. Remember, there was a second surveyor along with the property developer and another land surveyor that reviewed the survey.
So basically, this
They're the
complainant
ones that
was
expired.
unhappy with the survey, contacted, I'm assuming, a friend
Right.
who is a land surveyor with an expired license.
Oh,
So
okay.
when our
Okay.
expert reviewer,
I
I give them the
didn't hear
whole
it that way.
complaint, so they have the whole backstory.
Okay.
And he quickly said, "Who is this surveyor? I want to, because I'm not seeing these errors. I want to know what errors." And then when he saw it, we looked up his license. He's expired, and he said, "Okay, well then I'm not going to worry about it. I see no errors." But I can, going
I
forward on the
misunderstood
legal
that. Okay.
report,
See how you did
add.
it. I had to read it twice myself.
I can, on the legal report, add, like on the case information, the date of expiration for the respondents, and then make sure I include the date of the survey and the legal. That all of that's more
Based
clear.
on that, Mr. Chairman, if we don't have any other discussion, I'll make a close then, because we ain't gonna motion yet.
Motion to the end, yeah.
Yeah, well, motion to the end. I'll make a
So-
motion to the end.
You're in agreement to with the recommendation to
Yep.
close? All right.
Yep.
Everyone else good? Okay. All right. Very good. Well done. All right.
Case 4, number 2016048-171. A complaint was filed against the respondent after the property owners of an adjacent property offered to sell the complainant property that the complainant believed he already owned. There have been 2 surveys conducted on the properties, and there is an overlap between the 2 properties of about 3.5 acres, which is the core of this dispute. The respondent conducted his survey in 2005 for the previous owner of the complainant's neighbor's property and delineated the 3.5 acres as belonging to the neighbor of the complainant, meaning it is now owned by the respondent. The complainant, it is now owned by, it's not owned by the respondent. The land is now owned by the complainant's neighbor. I'm sorry, that's what I meant to write. Trying to keep it, not being able to use names sometimes,
Yeah,
it trips me up. The complainant found a survey from several years prior to the respondent's survey that shows the 3.5 acres belonging to the complainant's property. At the time the respondent conducted the survey, he saw that the deeds of the 2 properties caused the overlap issue, and so his survey demarcated the 3.5 acres as being in dispute. The respondent does not allege that the prior survey was incompetent, but says he interpreted the deeds differently and how he interpreted the natural monuments called for in the deeds. The survey in question was sent to an expert reviewer. The expert found that while there may be a genuine boundary dispute between the 2 property owners, the respondent's survey had not violated any standards of practice. It appears that this dispute is best left to the civil courts. My recommendation is to close.
It looks to be just your standard classic boundary dispute. Obviously, the reviewer found no errors in the standards of practice. I assume there were some plats generated and reviewed by our expert reviewer. Boundary disputes, we can't resolve boundary disputes. The courts can.
The surveyor even realized that there was a dispute and even made sure in his plat he said
As he
these
should.
areas are at issue between the 2 deeds.
Yeah, and as he should have.
Okay.
And well done on his part there. But yeah, I have to agree. Personally, I have to agree with your recommendation to close and let them resolve that in the courts.
Last case, number 5, number 2016055-171. This complaint was opened administratively to investigate allegations that were listed in a newspaper article about the respondent. The newspaper alleged that the respondent had been charged with multiple felonies and misdemeanors, including, but not limited to, aggravated statutory rape, sexual exploitation, aggravated assault, theft, coercion of a witness, and carrying a firearm in a government building. A grand jury indicted the respondent on October 24th for a majority of the charges. The respondent has until January 23rd of 2017 to either settle with the district attorney's office or this case will be set for a jury trial. Discuss.
Wow.
We have in our rules the right to revoke a license based on a conviction. There's not a conviction here, but at the same time, he has been indicted for these things. So I wanted to give you guys a chance to decide if you wanted to start taking action based on the misconduct allegations, or if you wanted to put this in litigation monitoring until after the trial plays out.
Well, my initial thoughts are, innocent until proven guilty, and he hasn't gone that far yet. Although those are some pretty serious charges, and there has been an indictment issued. So obviously, it will either be resolved in court or a settlement of some sort by the DA there. But again, we're bound by the rules as they're listed there, and it's on conviction. Is that correct? Okay? I just want to make sure I'm saying that correct.
What I think I can do is write him. So it's called like a litigation monitoring consent order, and basically what it says is that we're not going to take any action until after this specific litigation plays out. If he is convicted of any of these felonies, though, that he's agreeing to the automatic revocation of his license, and that way, if and when he is convicted of
those charges.
I guess I'm making the assumption that if he is convicted of these charges, that you would like to revoke his license. First, let's address that.
I personally, I'd be
okay.
right up there with it. Was there not something recently that came through here about felony charges? It used to be an automatic revocation of the license, but now is at the discretion? Am I dreaming, or am I?
No,
it was fairly recent.
It is at the discretion of the board.
Okay.
But that's more about granting licenses.
Yeah, okay, I think you're right. I think it was.
So if somebody has a conviction in their past,
right, that's exactly what it
you
was.
can
You're right.
consider it,
My
but
bad.
it's limited. But as far as your people who are already licensed, if they're convicted of a felony while they're licensed, you can.
Do the rules say may or shall revoke the license? Is that the discretion
That's
of the board?
why I wanted to determine that.
Mm-hmm.
And we discussed it, to interrupt, and I think we're both comfortable presenting it to you, even though we know that the case is living its course, just because the case can take a long time, and we want to make sure that we're doing what you think would protect the public in the meantime.
I personally have no issue with issuing a letter with just what you're saying, with the intent that upon, if there were a conviction of any or all of these charges, that immediately his license is revoked. Thoughts?
No, I think that's exactly what we need.
I just want to be clear, just for my own understanding, that up until this time of a decision is made on those charges, he's free to survey. His license is valid, assuming he's paid all his. Yeah. Okay.
I think that would give him some information as he heads into whatever negotiations come up with. This is his livelihood with the case.
I did not ask when I spoke with because I did speak with the clerk of courts, and I regret now that I didn't ask her if he had made bail out on bail. With these kind of charges, I would very high.
And do we know if this individual is active?
All right.
So just to recap, on one, I'm going to on case one, I'm going to close and issue a letter, but no discipline. On case two, I'm going to send a letter directing him to send a copy of the survey, and if he doesn't do that within a month's time, the board is issuing a $1,000 civil penalty, and that he has to inform us of any outside litigation involving these surveys. Case 3, we're going to close. Case 4, we're going to close. In case 5, I'm going to send a litigation monitoring consent order, basically saying if he's convicted of these felonies, his license is revoked.
Correct. All right, entertain a motion.
So moved.
Second.
All right, motion and second. Any additional follow-up on any of the 5 cases discussed? All right, hearing none, with a voice vote, all in favor of approving, say aye.
Aye.
Any opposed, say nay. Very good. Laura, well done. Excellent job there, both in not only the summation, but also reading them to us and discussing with all the facts there. We certainly appreciate everything you've done there. It's quite a bit of work, and it certainly is noticed by this board. Thank you very much.
I want to take do I have a minute?
You have a minute.
I have a minute here to talk
1 minute.
about, so, on that note, the department is going to be restructuring a little bit of how legal services are provided. So I will still be your attorney, but a lot of times what happens is I will present these cases to you, I make the analysis, the decision, and then if I can't settle them, I pass them off to a litigator. There's a lot of drag time in doing that, and so the department is looking at potentially changing it so that the same attorney who gets the case from the beginning and is making the original analysis also carries it through to litigation. So I will still be at every meeting. I'm still your attorney, so I don't want you to think I'm leaving, but at the next meeting, there may be 1 or 2 other attorneys who come to present cases much in the same manner. It hasn't happened yet, but since we aren't meeting again until January, I didn't want you to be caught off guard. If it's not just me, they probably won't sit down here for the full meeting like I do, but they might come during the legal report to talk about a case that they're working on. So I just wanted to give everyone a heads up about that.
Okay. So noted. Anything further? No, sir. All right, with that, I'm going to request a break for lunch here, and I guess we'll assemble back. It's coming up on 12 o'clock. Assemble back at 1 o'clock. Is that plenty of time? Yeah. Plenty of time? Okay. We'll try for 1 o'clock this afternoon.
Thank you very much.
Thank you. Thank you, Cody. Certainly want to welcome everyone back. Hope they enjoyed their lunch today and the nice weather outside, though it is warming up just a little bit. Okay, want to get back to business here. A couple items we still need to cover. Cody, I was going to ask you to address the newsletter. I know you've passed around a draft copy of it. I think everybody's had a chance to look at it. It looks great. Is there anything you wanted to add or mention to it?
Well, we're waiting on one more check mark from legal.
I reviewed it. I don't see any issue with it.
Come on, legal. Come on.
I probably, I imagine in the next few days, I'm just going to ask probably either Mark or Michael to also put their eyes on it. But I've reviewed it and see no issues, so I think we'll be able to move pretty quickly.
The picture we took in there, it'll be done as far as we're concerned, pending any.
Okay, so we can look for that on the website here relatively soon then?
Yes.
Great, good job. Thank you, Cody, appreciate all that.
Having went through this process, it's been quite a lengthy process to get back with the newsletter. Are we going to have these same hurdles now that we've got this crafted each time, or have we got through a lot of those hurdles so that it'll be able to be put out in a smaller time frame?
I think it's ready, set, go at this point. I think our intention is the newsletter out, another newsletter out as soon as possible, because we're basically ready to fill another one. I would say conservatively January, because I know how crazy it gets with the holidays. I would love to get it out before Christmas, but it'll probably be right after that.
I think quality and some timeliness routine would be the optimum, maybe.
That's our hope, because this is one of his strengths and passions, and so I think we're going to keep up whether it's once a quarter. Once we get into a good routine, then I think we'll be in a good shape. Good situation, yeah.
Great.
Good to hear.
Thank you very much.
Put you on the spot there,
Thank you,
Cody.
Cody.
Once a quarter. All right. Thank you again for all your efforts there. Okay, we do have a special guest with us today. Mr. Jackie Dillahay is going to present to us, as best I understand, the TAPS report. I think Bruce, the new president, wasn't able to make it, and I appreciate you stepping forward and stepping in his big shoes there.
Yeah, I got an email. Meeting, so I don't have the privilege of knowing what all went on there. Best I could find out, there was some discussion through the board of directors about the practice of unlicensed surveying, particularly about maybe an unlicensed individual using the stamp of a former employee without his knowledge. Plans for the 2018 will be the 50th year of TAPS, and planning for that conference to be special. And so the plans are in beginning stages of making plans for it. I think that throughout the chapters, it's my understanding there's been some discussion of changing the RLS acronym to PS or PLS. So I know that's going on throughout the TAPS chapters.
Have you had any feel for that, Jackie? I mean, either statewide or just even with the local chapter here, have you had any feel for it?
No, not really. I didn't see, and maybe it was one of the eastern chapters, I don't know if it's Middle East or Northeast, that they seem to think preference would be PLS. My personal preference would be PS, but that's just one man's opinion. I checked, our membership stands now about 507 through the last cycle, which we're starting the new cycle, so it's going to fluctuate going forward. And we do offer a lifetime membership now. I apologize, I don't remember the details of it. I think it's maybe 20 years worth of dues. You pay them all at one time for the not NSPS, but for the state portion of it only.
Right.
And we're planning a day on the Hill during the next legislative session. So needed, and it's about time. So that's really all I have.
Do you know if a date has been set yet on that day on the Hill?
No.
Okay.
To my knowledge, it hasn't. Probably February-ish sometime.
So I got an email the other day about the engineers doing something similar to it. I think they had a date established and all that, so hopefully.
I think they have historically done it for a number of years.
Yeah.
And it's something I think is needed. And, we are, the PAC has been pretty active this year. We've been successful in raising some money, but we also been successful in spending some money. So that's why you raise it, to spend it. So.
All right, Jackie, certainly appreciate that, and certainly want to make notice, Jackie, of course, being a former board member, having sat up here in years past. We certainly appreciate you stopping by. I know you're very familiar with the halls, and I'm sure some of the faces as well. Certainly glad to have you back.
It's good to be back. Good to see everybody, and always interested to.
Thank you, Jackie. Okay, I think that covers the TAPS report. Anybody want to add anything to that from the local chapters of anything? We're good? Okay. All right, we'll move on to the next item on the agenda there under Cylinder Legal Report. Laura, I think you had some additional information on the rules, is that right?
So I had I guess Cody had emailed a draft of rules out to you guys earlier this week, and then I've also printed up rules in front of you. There is a slight change in what I emailed out to you because in working with Michael and Kimberly, we realized that it might be smart to change the fees completely as opposed to just the changes we had discussed earlier. What I tried to do is go through the rules, and I mean, it's fairly intuitive, but obviously where it's red and marked out, that would be deletions. Blue and underline would be additions. And the idea here is to sort of separate it out so that we are talking about how we're going to deal with the state-specific exam and then the NCEES exam, and then also try to create a path where when they apply, they've got these examinations ready to go when they come to apply us, so that they're not coming and applying and then taking the examination and then applying. So I didn't know if you guys wanted to talk about that, if you had questions or edits, if you wanted to take time and come back to this at the next board meeting.
Certainly going to need some time. It looks like it's going to need some real sit-down thought, I believe, behind it. Just because of the logistics, I'm not questioning the work you've done, but the logistics of putting those actually into practice, plus reviewing the fees or penalties that are proposed here. Do you know, let's see, did you change, this is a question, did you change the values of the fees at all? I guess there was some, changing.
So that's the last section.
Right.
That's going to be changed. So we change it so that registration, renewal, and application and late penalty fees are still going to be set, sort of in writing. And then we changed it so that the vendors sort of set the examination price. So that way, instead of having, because these things change, say we end up with a vendor from the RFP that they talked about this morning, and then in 5 years, if they reissue the RFP, I mean, every time we need to change things, lower or higher, we would have to rechange the rules. So I think sort of not memorializing it in rules, but in fact saying that these are going to be set by the vendors. But of course, the board is still setting the price of the exam because you're choosing the vendor, right? You're the one that's controlling the RFP. So it's not as if you've given away the jurisdiction. You're just making it so that you're saying, this is our authority, and what we're doing is saying, whoever we choose, that price is what it is, and you need to contact them, and they'll let you know what the price is. So that is how, and Michael kind of helped me with this language. This is how we've done it on other boards, because you have to make sure that the statute gives the board the authority to set the fee. So you have to word it in such a way that it's clear that you're not giving away that authority, but at the same time, you don't want to hamper yourself.
Why was paragraph 2 on page 1 struck and that language put in its place? You're looking at apples and oranges right there.
Am I? Then clearly, because I'm confused. I was trying to make it so that the application comes to you with the required examinations.
But the point of that sentence is that 2 of the board members approved the application of the examinee to take the licensing exam. That's the point of that. It's
Right.
not to prove to us that they passed the other exams, because that's within the confines of their application. In other words, that statement is so that any 2 of us can review an application and concur that we approve that applicant for examination.
So were you not trying to have them take the examination and then apply?
No, that's a whole other subject. You're again, now we're back in apples and oranges. What we were talking about there was the FS examination, but this document here we're talking about is the TS examination.
Okay.
So it's two different things.
So let's rewrite that. I'll keep that same sentence. So I'm going to get rid of my new language. I'm going to keep the red struck out language, but then I want to make it clear what test we're talking about here.
But that doesn't matter what test you're talking about. At the end of the day, we have to, 2 members of this board have to approve any examination. Well, I shouldn't say it that way. 2 members of this board at this time, if we yield on the FS, will have to approve the PS and the TS applications. The FS application will come after the applicant, if we approve it that way, after the applicant passes the test, and then we will still approve that application, even though they have already passed the test, for them to be certified as a PSLIT. And in
I
that,
feel
and
that we could write that clearer.
in that spirit,
so.
and in that spirit, over where the examination statement is on
Okay,
page.
hold on. Let's stay on this one
Okay.
first. Let's make this say exactly what you want it to say, but I mean this is written confusing to me because I don't think it specifies which examination you're talking about, which is why I made the assumption that we were still talking about the other exam.
Well, you have to realize that this particular rule was written, I want to say, let me make sure I don't want to misstate.
This chapter hasn't been revised since at least 2002, whether or not that was written before then.
I think the last time it was touched was 1992. So, you know, we are really dealing with a dinosaur. So in 1992, for what it's worth, an applicant could apply and be approved to take all three examinations within a 2-day period of time and become licensed if they passed all three examinations.
Statement applied really then to every one of the situations. Two people had to approve and move it on. Okay, so now we're treating them different. So
Still
yes.
applies, but we've got a different roadmap
Right, right.
to get to the same place. Yes, ma'am. Yes, ma'am.
Okay, so let's reword this so that we're being specific and clear then. Let's say if 2 or more board members recommend examination of an applicant, let's say an applicant for what? An applicant for the PS or the,
Okay. If 2 or more board members recommend an applicant to take, and I'm not very good with words, to take the PS or TS examination, such examination, I don't understand the such.
okay, let's start this way. What is the body of people that fall into this category? What would I have to be applying for this to apply to me? Do you see what I mean? Say I was an applicant. What am I an applicant for? Is it for the PS? PS. Okay, so let's say if 2 or more board members recommend examination of an applicant here we're recommending examination. That's what this is
Approve the
about.
application as a recommendation of examination, yes.
Approving.
You have to prove, the process is you have to approve the application, and the result is it allows them to take the examination.
I get that, but what I'm okay. If 2 or more.
Because the reason we say it that way, Ms. Martin, is because we have out-of-state or comedy candidates that would only take the TS examination. So atypically, in-state, the PS and TS are tied together, and the applicant would be able to take both tests in such order as the testing is now doing. But because of out-of-states, we have to maintain that control for the TS.
So what exactly? So they're not applicants for the PS or the TS. They're applying to be licensed, right? And then we're saying to get this license, you need to take this examination.
Correct.
Okay. So they're applying for a land surveyor's license or the PLSI. Is it PLSIT?
No, keep that one. Just keep that one to the side for a minute. Let's stay right here where we're at. Let's don't mix them up.
Okay, if 2 or more board members recommend examination of an applicant for the PS or TS exam,
Applicant shall be allowed to take it at the next available time or whatever words needs to go in there.
applicant is approved. Or the necessary. So instead of the new language I had put in blue, I'll say if 2 or more board members recommend examination of an applicant for the PS or TS exam, such applicant is approved for the necessary examination. Okay.
So I hate to, but this is then to hopefully clarify the final piece. The VFS, we're going to address one more time here to decide if we can treat them down another avenue. But these two, at least at this point, we're assuming that we will always review and approve them before they test, right? We're not thinking of approving them to test and then if they pass, then approving them for licensure. We're not.
We have some rumblings in NCAAS among some jurisdictions to allow, because of CBT, to allow the PS to be taken like the FS is taken.
Right.
But there's no one has stepped to the plate yet
Okay.
to
Okay.
create a direction about
Okay.
that.
Okay, so at this point, so at a later date, we may have to tweak that if we go down that avenue for the PS. Okay, that, I got it. Thank you, thank you.
Now, on the other thing on testing on page 5 at the very bottom, and I realized we weren't going to go over these, and now we are, and I apologize.
I just wanted to finish the other one.
I think the order is not critical, but it should be changed to say a candidate shall schedule the fundamentals of land surveying FS and or the practice of land surveying PS exam directly with NCAAS, etc. There is no exam for the PSLIT. The result of passing the FS and having an approved application with the proper credentials on that application yields a PSLIT certificate to the applicant.
So I can say a candidate shall schedule the fundamentals of land surveying, FS, and or the practice of land surveying, PS, examinations directly with so on and so forth. And then I'll just completely strike out the PLSAT. Oh, I had a question that I wanted to bring to you guys. If you'll notice on page 3, twice I inserted the language state specific. And I had used that language because that is sort of what is the phrase that's used, but that's kind of colloquial. Should I just say the state examination? Or do you want me to specifically state
Well, we
it?
refer to it as the TS, which is the Tennessee State Specific Exam. That's the way we refer to it, as we were referring earlier in the previous change that we discussed.
Yeah, I would suggest that
I'll just insert the word Tennessee.
Tennessee right in front of it, yeah, absolutely.
Okay. I just wanted to make sure I was using it
Right.
in a way
Yeah,
that
right.
everybody would get it.
Page 2 at the top, paragraph 5. I do not. I think I know what you're trying to say, but that should be directly tied into our conversation on the FS. No, see, I really don't like the way it's worded. Of course, that's me. You have to understand that, but it just doesn't apply here because the applicant is not supplying a vendor with an application. That's not what they're doing. That's not what they're doing.
Well, so here, let me explain why I wrote that, and then you can tell me why I'm wrong. So my idea is that what we were trying to do was sort of bypass some of the additional steps by letting these people go take that one exam directly. And my hope is that that instead of the board, first they have to apply to the board, wait for a meeting, and then the board reviews, and then they're approved to go on and test. For these vendors, usually we delegate the authority for them to look at somebody. If they're not qualified to take the test, then the vendor isn't going to take their money and make them take the test.
Well-
But they have to, the student has to be responsible for turning in whatever the vendor says that they require to determine
let's-
who's eligible to take the test. Does that make sense?
Yes, ma'am, it does. It makes perfect sense. However, in this particular instance, we're now broaching the FS examination discussion. And the question here is whether or not we want to allow an applicant, what would be a routine applicant for this board, to go ahead and take the FS, period, without any application to us. And the only thing that they would be required to do would basically contact NCAAS, fill out the very minimal testing form that they have, which has nothing to do with what state they live in, nothing to do with what their experience is, their education, none of the above. And then NCAAS would allow them to come. They would do the proper security and give them the proper codes and numbers. They would let them schedule a seat at an appropriate testing center. They would then go take the examination, okay? Then upon
Have
getting...
this in the wrong place, because I wasn't trying to talk about NCAAS. I was
Okay.
trying to talk about the test vendor that will likely get
For the
picked
other
from,
two.
yeah.
For the other two.
So maybe that needs to be in a different place in the rules, but I'm talking more about like the PSIs and the Pearson views. That is what I'm referring to, because they actually
if we
will
go with this,
determine, okay, yes, you have the education X, Y, and Z. Yes, you can come and test. Otherwise, they
Well,
revert
the-
that probably over to Roxanne.
Ms. Roxanne, correct me. The way I see it happening is this board still approves the application. And
Those
then
two exams,
Let's assume that the RFP we discussed this morning is in place. Okay, let's make that assumption. All right, this board still approves the application. And you then have knowledge, you and your staff have knowledge that John Doe is approved to take the PS and the TS examination. Okay? Under that scenario of the RFP, your staff, your office notifies vendor X that John Doe can take the PS actually two vendors. You'd have to notify NCAAS for the PS, and then for the TS you'd notify vendor X that was qualified under the RFP. Okay, then those two vendors know that John Doe can come and take that test. He's approved to take that test. That's all the approval that they need. John Doe is not submitting an application back to these vendors to make anything happen. All John Doe is going to do is fill out whatever appropriate form that they
pay for
require,
his seat
that
or her
vendor
seat.
requires, and he's going to bring them a check.
Right, right.
That's it. So we don't have a dog in that race. And they are not submitting applications to the vendor.
Applications all come to us.
Yeah.
And like you said, in the future, we can address, is there any way for them to go directly and test, in the case maybe of the PS, and bring results back? But yes, the way the RFP would flow, once the board approves the applicant, that's how it is now, we can work out a method with which we basically go to a secure site and upload their information to the vendor. And we can determine how NCAAS does it the same way.
Right.
So then in that case, this additional information may not be needed, is what you're saying.
We can strike this from the rules. When I was under the impression that you guys were trying to bypass some of these steps and let the
For a different
vendors.
examination. We got 3 tests we're talking about.
I know.
But we're focusing on 2 of them
I'm
here.
trying to talk about. Okay, so let's just get rid of paragraph 5.
Okay.
We'll move on to the next.
Have any other comments?
Well, not until I review it, the rest of it. I mean, I just quick reviewed it.
My plan then is to incorporate these edits, and then I can email them out to you all.
Yeah, if you would.
And you don't have to wait until the next board meeting. Just so if you have comments and you want to email me,
Okay,
because
just
yeah,
mark it up and email it.
Is that
Yeah,
okay?
Directly to Laura myself.
Okay.
let me make these changes that we've discussed today and get it out to you all, and then review that, and then send back your comments. So
Okay.
maybe at the next meeting we can make a motion and move forward with this.
Definitely needs a little more
Ms.
sit-down
Martin,
thought, I think.
Before we leave, go to page 3 and paragraph 5. In that you have, in the second line, under paragraph 3, did you mean that to be now 4? Because that number has changed up there at the top, and that's
Yeah.
that's what I was referring to, right?
Yes,
Okay.
yes, because we added, if you look on page 2, we added a paragraph between what was paragraph 2 and 3. So I numbered that 3 and then renumbered
should-
the last 2.
So that number 3 should then read 4, right? Okay.
Okay, so you're good there, Gavin? Okay. Laura, if you don't mind, I'm going to take liberty of allowing
Oh,
our
yeah,
guests
that's
that just walked in. Alan Crawford, certainly welcome you and all the other surveyors that have come in with you. Certainly want to welcome you to the board meeting today. And I understand you have an issue you want to address with us? You're certainly welcome to the microphone, sir. Do we have a sign-in sheet? Usually we ask our guests to sign in of some kind.
First of all, thanks for the welcome extended through your board attorney, Ms. Martin. Appreciate your swift attention to the case that we're here interested about today. Really can't believe how quickly it moved. Normally, I would think that there might be head before a case of this nature would be settled, but
Dual close, Sparky.
so it may be
There you go.
that due to your action, the problem has been solved. But we may have evidence to the contrary. We don't have evidence with us today, but the area that the respondent in the case practices in is kind of a small community. And I'm about his actions there. We're trying to get evidence from people who require surveying services that the respondent is continuing to offer surveying services, especially in Hendersonville. Mainly, we want to express our concern about that. We want to thank you for your action, but also we want to continue to monitor. Probably not time to talk about the verbal evidence that we have, but we want to bring to you.
Okay. Alan, just to kind of get up to speed with what you're talking about, I understand, Laura, by chance, do we have the case number?
Sure.
Just for the record.
This is case number 20150222421, and I want to take this moment just to encourage you as you talk about this to keep any potential complaint that could come before the board needs to be anonymous in nature. So while we can talk about the subject matter fully, I don't want you to say any names, please, or anything like that today. I just want to take that moment. I should have told you that beforehand, and I apologize.
And that's really to protect everyone involved here. We certainly don't want to overstep our bounds in any way, and so we try to keep these things as what we say clean as possible. But if I can just kind of get up to speed, there was a case that came before us not too long ago. I understand that we did pass a ruling, and it's my understanding that the respondent has satisfied that ruling to the board's satisfaction. Is that correct?
That's correct. The board authorized that complaint for formal charges, and we issued a consent order for $5,000. If you'll recall at the time, I think I had evidence of 5 instances of either the offering or the holding out as a land surveyor. This was an unlicensed activity case, and so that was the reason for the $5,000 consent order. Pretty shortly after that meeting, I received the consent order signed with a $5,000 check.
Okay, so in terms of the action that this board has taken, the case essentially is closed as they've satisfied the issuance of the consent order. Okay, all right. And it's my understanding, Alan, that you're here this afternoon to basically express that you're looking to possibly take this further, and there may be some other actions outside of what we've already dealt with here. Is that correct?
Yes, you have a letter from me.
That's right.
That expresses specifically what we would like to see. Also understand that the district attorney's office does not. So I understand the practicality. Also believe that we are about to demonstrate that the practice is ongoing by the respondent in this case, in which circumstance I would think that you would want to know about that. My question is, do we need to file a separate complaint for that, or can we deal with that under the one?
It's my understanding that that would be, and Laura, of course, correct me if I go wrong here, that would be a separate complaint in that what we just addressed, the original complaint has already been addressed and so to speak, the file is closed, so to speak. They've satisfied the consent order to the extent that the board has instructed. Any further infractions that have been discovered can certainly file another complaint, a new complaint, in which case, when it's presented to the board, we'll take the action from there.
Well, the civil aspect has been dealt with, but as we've discussed, there is a criminal aspect as well. Could that not be dealt with under the current complaint?
I don't know that criminal actions can be handled by this board. I believe those have to be referred to the DA of the local jurisdiction. Laura, am I right there?
Correct.
I believe so, yes. Okay, so as far as any criminal activity goes, I don't know that we can handle that. However, a local district attorney could, and that's beyond the purview of this board.
Mr. Crawford, thank you and the other gentleman for coming today. I want to say, if it's not apparent, that this board is very concerned about this type of situation. I'm sure that if you've heard me speak about it in the past, that my passion for this is as bad as it gets, as far as I'm concerned in our profession. And I'm the bad guy on the board, and I'm the guy that's always throwing the big numbers out for the fines and everything else. And, our board was limited to the complaint, the facts that were presented in the complaint, and unfortunately, due to our statutes relative to penalties that you'll find, as Mr. Northcutt would say in the Blue Book, that you'll find in there, we are even more limited. So the thing that I would say to you is, if there are subsequent complaints in this matter, other matters, Ms. Martin may correct me, but it's important that as many facts that can be found and determined can be presented to the board for their review, because of the limitations that we have in our penalties. That the more facts you have times something equals something else. And obviously, a continued, let's say, lack of stopping what may have been going on after being punished or reprimanded in some way, obviously, the second time around, in my mind, is more egregious and more severe, and may require, as Ms. Martin said, may require other actions by other either attorneys or courts of competent jurisdiction. But I want you and the gentlemen here that are here today to understand that we are most sympathetic to the cause that you brought before us, and that we certainly will act to the maximum that our state statutes allow us to act to. But in the same token, what happens many, many times with our complaints is they are although very factual and very to the point, they are very limited, which ties our hands about what the severity of the penalty that this board can issue if, in fact, the respondent is, or even an unlicensed person, is found to be in fault. So I just want to share that with you, that as you move forward, whether it be this case or any other case, the stack of facts is critical. One, one's bad enough, but if there's 100, it's obviously worse, but 100 dictates a different punishment than one does for the same offense. And that's the point I'm trying to make.
And just to add to that note, kind of add to what Tim's saying there, on that last case that's been resolved, we found a total of, I think it was five infractions, and we levied the maximum penalty on each one of those 5 fines, obviously $1,000 each. So with that being said, I do want to stress that myself, I think I can speak for the board here, says that we do take this very seriously, and on that particular case administered the maximum fine that we could. And certainly if another complaint does come through and it's similar factual circumstances, I can speak and say that I would attempt to do the same thing again, issue the maximum fine that I can or that we're allowed to as a board here. If there is a path to prosecution for criminal offenses outside the purview of this board, I would hope that there's any resources that this board can provide to you, whether it's by letterhead or anything like that. I would certainly like to offer that to the extent that we're allowed to, because like Tim said, we take this very seriously. This is just beyond what is right, and we need to enforce to the maximum that we can to stop this. And paramount is the protection of the public, which is what's in danger here.
I think if you listen to our last board meeting in July's minutes, I think you will have heard me mention that because of this egregious situation, had we been able to establish the advertising of his company name over a period of time, it could have been fined $1,000 a day. And I gave an example in those minutes, which are a public record, of if it was 400 days, 400 times 1,000. Well, that's a lot different than $5,000. Clearly. But we had to go through our routines, our procedures, because we could not verify that. And the things that Ms. Martin was able to verify was what we had to use. But I just wanted to let you know that if you hadn't viewed those minutes, I was ready to put all the teeth in the world in it. But we didn't have the bullets to go in our gun.
I saw the transcript, and I assured everyone here that we shared we do have a lot more information than what was presented to you. However, I think that we will be able to present ongoing evidence, and that's what our mission is now, is to demonstrate that this activity is occurring. And as to the advertising of services, I think we may.
Lastly, I want to say to you, Mr. Crawford, and all the surveyors that are in attendance here today, I, as a fellow professional and as a board member, greatly appreciate your stewardship for our profession. Because whether this person was a licensee or not a licensee, we don't have any room for them in my mind, and I appreciate that stewardship. And as I have learned being on the board, that's probably the hardest thing in the world to do, is to see a violation and act upon that violation appropriately as the law requires you to do. And that's just a tough thing. But I have learned that it's the correct thing, and that I wish more would. Not that anybody's out on a witch hunt anywhere, but if something is what it is, it should be dealt with.
We weren't looking to find this evidence. Well, initially, we weren't. It came about, but it was undeniable. But now we are.
Well, as it so adversely affects our profession, it greater adverses the public, and that's what we just can't tolerate it affecting the public. And as I said in July, as far as I'm concerned, it's just straight up stealing. Is all it is.
Alan, I know obviously you brought some other surveyors with you. I certainly want to give them the opportunity. If any of them want to come forward and speak, I certainly want to extend the invitation to each of you there. If there's anything you want to add to what Mr. Crawford has said, you're certainly welcome to step forward. Yeah, please do. That'd be fine. Yeah, just if you get in front of a microphone, of course, state your name for the record there, please.
Okay. This is the complainant in the case. Is he allowed to state his name?
I'll just keep everything on a general basis, if that's okay.
Yeah, let's don't state the name.
We're going to need you.
If you're talking about the case that's already closed, that's fine. But when he started talking about new information that could result in a new potential complaint, I don't want to. I don't want to taint that.
Thank you for letting me speak. I'm Benny M. Cantrell, and I would just like to add to what Alan had said, that we appreciate all of the care and concern that you guys exercised in looking at the case and ultimately making a decision on the case. So I just wanted to express my appreciation, and also, while I've got these other guys here, express my appreciation for them, the way that they rallied around the situation and how they took up for the profession, because we're all pretty fired up about it.
Should be. Yeah, Benny, so often we hear in our own communities about, suspected violations of, surveyor here, unpracticed surveying, of any kind. And a lot of it is just a lot of talk. But I certainly want to commend you and obviously the group of surveyors here that have rallied together against this violator, about the way you filed the complaint. You went through the procedure the correct way. Sometimes it's not as quick as this one did go through pretty quick, which is good. Sometimes it doesn't work that way, but it just shows that the process does work. And I certainly want to encourage all surveyors and the public that, if they see a violation that they suspect or know of, file the complaint. That's why the system is there. That's why we're here, is to handle those kind of things along with our staff. And so the system does work. I was glad to see how quickly it did get resolved. Unfortunately, there may be some more information here that may be coming our way, but we'll see. But I certainly appreciate both y'all's time and everybody that came out today. That's you took personal time off out of work and family and everything to come here and present your case, and you've done a fine job.
It means a lot. Thank you.
Thank you.
Time today.
Thank you very much.
Thank you, Alan.
Good to see you.
Appreciate y'all. Okay, all right. We're going to get right back on track here. Another item under legal report, the automatic approval of the FS exam. We kind of touched on that a little bit a second ago. Is there anything else we need to expand on that?
I think one of the items with that, we touched on it at the last meeting, which was wonderful, and I know it was a lot to process at that meeting. So we kind of thought we would readdress. Are we at the point where we think we're ready to have a motion to release that FS, or do we still need time and leave it alone?
Let me tell you, something we're going to cover a little bit later on was the application revisions. I had done some homework looking at some of the other states and how they handle their applications, and a lot more states are allowing the FS exam to be taken before the application comes through. And we talked about all the improvements of efficiencies and obviously less work on the effort of the staff and the board here. I just think it's a positive all around. And quite honestly, I kind of wonder, what is it that's holding us back from going that way? Is it an issue of rules that we need to have changed? What is it on our part? I don't want the board to be the holdback, is what I'm saying. I don't want to speak for y'all, that I think we're all in agreement here that it's a positive way to go. Other states are doing it. It's more efficient on everybody's part. It's win-win all around. So I just kind of want to see what the status is. Is there anything that the board needs to take action on in order to start allowing this to happen? Or do we have roadblocks that we need to perhaps tackle and get underway?
I don't think that we have any roadblocks. The only way I looked at it, the original paragraph that we were kind of back and forth about, where I clearly was confused about what exam we were talking about, that was the only thing that when I read it, I thought was confusing if we're going to allow people to apply straight to the vendor for a specific test. But even that is written with an if. So I don't know that we have a roadblock if that's something that we want to do. But if that is something we want to do, I want to make sure our rules are supporting that decision, and it's clear to someone reading rules, trying to figure out how to apply,
right,
that they can tell from the rules what it is they're supposed to be doing.
Well, this is a huge thing in my mind for one, our newsletter, and two, our website. To help clean up that roadmap that you're talking about, Ms. Martin. Public Chapter 714 is what we're working under right now as far as our roadmap. And it simply stipulates that to be certified as a PSLIT, the applicant should do the following things. but it does not, as I read it, it does not stipulate that those things have to be in that order. And obviously those things being an application, be of good character, reputation, references, comply with the requirements of the chapter, and then pass the exam. So I don't see that the way I read this, but I certainly don't have any legal knowledge at all. But the way I read it, it does not lead me to believe that we are tied down to taking the application before they take the test. So NCWS has several ways of approving. One is what they call an automatic, and in that option, the candidate at the time of registration automatically the NCWS will automatically approve their system approves them, but they ask them to attest that they've met the board's requirements. They do ask that question, and I'm pretty sure that question, I know it is in the FPS, and I'm pretty sure it is in the FS, and that may be something you want to investigate through your MBA system with NCWS.
That was my understanding as well, that there is an attestation. You have to select what state you'll be applying under and that you've read and meet.
We would need to update, and you're right, the website is probably the first place. And then if we can get it by, and I think we can, the January newsletter, we make it very informative to everyone, that we're now have made this great leap, and they can go straight there.
As I spoke earlier about when a lot of these rules that the chapter we were just looking at went into effect in 1992, our roadmap is so different. And it's changed over the last 3 years with all this CBT and everything else. So, I'm not real sure, because I get a lot of calls from employers that have, somebody that's wanting to come take the test, so forth and so on, and they truly don't understand the current roadmap. And I think that's imperative on us, hopefully through the website and the newsletter, to be able to try to do that. I mean, even if it's an appearance at one of the association meetings or whatever,
Absolutely.
however we can to promote that, because that way this prospective licensee better understands what they've got to do and how long it's going to take them to get there if everything goes according to Hoyle.
I agree. I think I have not seen any other obstacles either. I think the board would have to give us the authority to then reach out to NCWS and tell them Tennessee's also on board. We're going to be approving the applications after the exam. So you're welcome to take anyone that applies for it, Tennessee.
So to paraphrase what you said, if we make a motion to approve automatic testing
For the FS.
For the FS in Tennessee, then you would then take the lead and coordinate with NCWS, get their language, and Ms. Martin would basically verify that there's not any legalese, any problems between either our statute or that.
Right, and at that point, we will make sure that nothing specific about that exam needs to be in these rules, that, just simply says an FS applicant may go directly to the NASH and spells it out and apply. If you've otherwise met the educational requirements, whatever.
Because the explanation part there is on the back end. Once you've passed,
In the application, right.
The only fly in the ointment that I see is atypically when an individual fails an examination 3 times, we want to see them. That's the only fly in the ointment that I can think of.
That exam as well.
Right, and you see the way the FS works with NCWS on CBT is once you register and they give you the ability to find you a seat, the day you take your first exam, in other words, for example, let's say I registered today and I'm approved, okay, to take the exam. I decide I want to take the exam on January the 30th, okay? That date becomes my first day of my year. So in 12 months from January the 30th, I have 3 attempts. And they lock me out at 3. And if I fail all 3 of those attempts, basically what we have done with this board in the past is we ask them to come see us. We need to kind of know what's going on. And this time, we won't know anything about them this time because we will not even send an application.
Right, but that's a good question to ask the NCWS because, they're still controlling the date. Like you said, that 12-year clock starts here.
Right.
They block them, and I understand how that works. The other testing vendors do the same thing. So at that point, they very likely have a way to let us know who this candidate is. that's failing. I'll find out.
Just as they'd let you know that candidate A passed or whatever.
Correct.
Well, then in turn, internally, if candidate A passed, then your staff would have to send candidate A a letter and say, now, for you to have a PSLIT certificate, you need to make application to the board with such fee, etc. And then at that point in time, if there was any deficiencies, we would tell that individual what the deficiencies were, and they would have to get those taken care of in order for us to give them that certificate. And then once they actually get that certificate, that starts another meter running for their experience moving towards the PS examination.
So and we can keep definitely to a point where we're all comfortable with everything, we can keep asking questions and addressing. But if the board agrees and motions that we proceed, I would need to reach out to NCWS. I'd have to get the paperwork, whatever I need to fill out, and it may be as simple as a form. It may be as, okay, I got Tennessee marked off. But I want those details. How are we flagged when they fail the 3 times? How does that clock start? When they pass, what do they send us? Or is it up to the candidate to say, hey, Tennessee, I'm here. Here's our stuff. Get all those details. And then I would imagine that by the January meeting, I can actually report back and say, you all gave me the motion and the approval. Here's where we are. It's in the newsletter. It's getting ready to be changed on the website. Here's the next step. And we have the go-to, the live date for that to go at that point. Because right now I think it's too soon for a live date, but it's definitely not too soon to cross all the other T's and get it in motion and then determine before you see the next round of rules, do we need to put it in the rules? Yeah, I'm good.
January enough time, you think?
To reach NCWS,
Oh, yeah,
I would
that's no
imagine so.
problem.
I mean,
No.
we're not talking, do a bid. We're not talking
No.
it's just a matter, and other states are doing it, and I know from our meeting we learned that they are. It would just be Tennessee's on board with this one. We're not there with the PS exam, but we are with this one. We want to go ahead. What do you need me to do? And they'll send me paperwork or whatever is needed.
I would think she would have her answer the same day she sends her email.
That's my thought.
Good. Yeah, let's hope so.
Okay.
That'd be great.
Ask a question because I probably need to ask Tim, but I'm not sure. If someone wants to take the FS exam and they don't turn in an application, when do they pay their fee for that exam, and how do they go about doing it without making an application?
Okay, there's 2 fees involved.
Okay.
The first fee is involved with NCWS and the basically pays the test vendor to do it, which
Yeah, that's what I was
is
wondering.
$225 off the top of my head for the FS exam.
Yeah.
So when when NCWS says you can go get you a seat now, then they tell them to go get a seat. They find out wherever they're going to go. They call them up, email them, whatever it is they do to get a seat. And then when they get the seat, they tell them, the vendor tells them that you need to bring a check for $225 or whatever, mail it in ahead of time, whatever the vendor's structure for that is, whatever it is, whatever it is. They go take that test, okay? Then NCWS notifies them. At the same time, they will notify Roxanne's office.
Okay.
And they'll say, little Johnny passed the test. They send little Johnny the email. They'll send Roxanne the email, okay? Then she now knows that she should send them a letter and say, okay, you've passed the FS examination. In order to be a PSLIT and have your certificate, you need to fill out this application. You can find it on our website, whatever that may be, and send in a check for $25. That's what it is currently right now, okay?
Yeah.
And then they do that, and then at our next meeting after she receives it, we look at it, and if they have met those criteria, we approve it, then she can issue a PSLIT certificate. That was something I did want to ask you about on the certificates. We were looking at the certificates strictly for the licensee. We also have been giving certificates for the land surveyor in training. So I wanted to mention that. So in other words, the folks that passed and see, with our licensing system, as far as the way the licensing system numbers folks, when I apply, if I apply today, I get a number. Well, that's my number from now on. I'm not a fan of that system, but I understand why it works. Because we can't say that we have licensees from 1 to 3,500. We can't say that because there's all kinds of scenarios.
Correct.
But the way that thing works is they get their approval through the system. Then that number, their PSLIT number, is the same number as their license number. other words, if it's 3,800, you are a PSLIT number 3,800. When you get your license, and please check me on this, when you get your license, you're now RLS, PS, PLS, whatever you want to be, number 3,800.
That's correct.
Am I saying that correct, Cody? Thank you, Cody.
So Cody, we just basically upgrade them from one stage to the next and maintain that ID number.
Yeah, once they enter our system, their file number
goes with
is
them.
their license
Gotcha.
number. through
Regardless of the
everything.
rank that they're in, they just keep going. Okay.
And if they expire and reinstate, however many years,
Doesn't matter,
we
comes
got a
right
guy
back.
from-
Right. Yeah, you get the same license.
And that
plate.
same number makes sense from a historical, if you
Oh,
had
yeah.
complaints and all of that comes with it. So I get that. I didn't
Yeah.
understand. Okay. Now let me ask you about this piece then. Did the certificate that we gave our trainees, is it smaller? Was it
Same
same
certificate.
one?
Same certificate. Yep.
That confuses me, but
Well, it was. I mean, the boys in my office have got them. I never took that part of the test, but the boys in my office have them, and it says land surveyor and training.
Agreed.
I'm
But
thinking of
they
that
were-
symbolic
But
thing.
it is the
I'm
same.
probably-
It is the same size.
Okay.
Currently, it
Okay.
can be something different, which
Okay.
I think is an outstanding ideal.
Okay. Don't you? I mean,
themselves on their own credit.
Yeah.
okay. Okay.
Yeah, I think
So,
that's
so have we stopped printing those as well, those certificates?
I was not aware that.
Okay, that they
of the
existed. So we will look into those
Yeah, we had
and
a-
find not, I mean, still a good caliber, this is what you get to post and put up, but not quite the same.
Right,
Okay.
yeah, it could be smaller, and it's certainly fine. So I think, Mr. Chairman, where I hear that we're at is you need to make a motion, and I'd like to make that motion that, that the board give recommendation to the staff to check into all the pertinent issues, legal, et cetera, that's necessary for Tennessee to have automatic approval with NCAAS for applicants to take the FS examination before they actually apply to us.
All right, is that the motion?
That's it.
That's the motion. Need a second.
All right, second.
All right, any further discussion on that? Okay, we'll take a voice vote for approval of the motion. All in favor say aye.
Aye.
Any opposed say nay. The ayes have it. Good, I look forward to putting that into motion. And I think ideally, Cody, help me out here, if I understand the system, the way we're trying to get it to is they pass the exam, they make application, the application gets emailed to the members of the board. Upon approval, right back at you, and the
That application
certificate can
that-
get mailed out.
Before the next meeting, that application could move that fast.
Oh, yes.
That fast,
Oh,
that's right.
yes.
Just that fast. All right, we're getting there. All right, climb out of
And,
the
and,
trees.
and it should help you all too. Should be a lot simpler for you all.
All right. Let's say surveyors in Tennessee climb out of the tree, start cooking with fire, right? Okay, all right. One more item under legal report. Laura, an update on QBS. Is that right? We have something to report on that?
Well, yes.
Uh-oh. Finally, we have an attorney that can tell us something, good or bad, finally.
Let's hear it.
Well, it's not good or bad. It's sort of just update. A while back you had asked about this, and I like hardly even remember the conversation. I think it was finished up in that last meeting, or that first meeting I had got on. I had drafted an attorney general's request, and I have gotten approval on most of the people in the department. But what I really need today is for just a signature, because it has to come from the board, and then after that we can move it on to the attorney general's office. I do apologize for the delay with a lot of the transition, I think. But this is also part of the restructuring, is because things like this always tend to come after I finish the legal report. But I do have it here today, and it's been approved by Michael and Mark, and it's pretty basic. It basically goes through the statute and asks if, under QBS, if land surveying would fall under construction services. So that's the crux of it, but so that the Attorney General knows where we're coming from, I have to go through the statute that talks about QBS, point out where we think we fall under it, and then ask them if they would agree with that analysis. So I can sort of make this a priority and get it going moving forward.
Okay, very good. I think, I'm sure we'll each want the opportunity to review the letter, but I'm sure that that if we all agree, we could have it signed by the end of the meeting today, I'm sure.
And
That'd be good.
I personally want to thank you for your efforts. I've been beating this horse for about 4 years. So, yeah, and it means
And
a
I
lot.
should have brought it back at the July meeting, and it just.
I'm certainly not insinuating you've had it
I
for 4
know.
years because I beat the horse before you
I
were our
know.
attorney. But I really feel like that it's another step for the surveyors in the state of Tennessee to be known as and recognized clearly as professionals. I really do, because it puts everybody in a more level playing field, and that protects the public's interest.
Absolutely.
So that's why that I've been so
Oh, no, I
emphatic
understand.
about this.
I left that March meeting and thought, well, now I have to figure out what QBS means, and and then I had to. So it's been a slow process, but
Well-
this is the letter that me, Michael, Mark, and I are all asks it the most straightforward, clear way, and then after your signature, we can sort of move.
No,
it
Ms.
along.
Martin, I know that we talk in a lot of acronyms and a lot of different things that you're not necessarily familiar with, and I understand that. And then I add insult to injury with my lack of proper East Tennessee English to try to explain things. So, but no, I understand that, and I just want you to know I really personally appreciate your efforts on this.
Absolutely.
And I know the surveyors across the state will also. And I hope that we get a good positive response from the Attorney General on it.
Laura, do you have any feel for how long something like this takes to get back? I know everyone is different. I understand that, but just estimate, are we talking like 2-3 months? Are we talking 2-3 years? What do we?
I don't think it will take 2 or 3 years, but I also would be uncomfortable to how quick or fast the AG. The most recent opinion that I requested did come back in 2 or 3 months, but I know that other
But
times
can
it's
happen,
taken
yeah.
longer. It
Yeah,
can
it
happen
can happen,
quickly. The few people over the AG's office I've worked with have all been great and efficient, so hopefully it'll happen quickly, but I couldn't guarantee that.
Not asking you to.
Well, I'm sure a lot of it also depends on the hard work that you've done. And I know you've got it very ordered from A to Z, so it makes their job easier, so it should be quicker.
All right. Again, thank you, Laura, for all that. Is there anything, Laura, that you need to add on the legal report? Or have we covered everything that you
Just
have?
one last thing. When Mr. Allen, when Mr. Crawford was here, did you want me to refer that complaint to the DA's office, or were
Not
you
yet.
sort of just giving him
Right.
the go ahead if he wanted to?
Not yet. I was basically putting the ball in his court, that if
Okay.
there is action that he wanted to take, I was offering
I got it.
services that we can extend to him. So
I
for
do
right
think
now,
if they
don't
have
there's any
additional
action.
information, it's best that we just stay in our lane and act
right,
on whatever they can give us, and we can investigate. But I just wanted to make sure you weren't expecting me to do. That's it.
All right, well done, Laura.
Thank
Thank
you
you
very
so much for that. Okay, we're going to move on. Next item, application review. Oh, wait a minute. Jackie, you got something?
I have an extra
you-
one.
Look at it now if you want to.
You want to look this? Let him look at that one, then we'll bring it back up here.
I had it.
Okay,
Yeah.
sure,
Give me that back and we'll sign that one.
sure.
All right, moving on here, the next item on the agenda, the application review. Cody, that's probably under your
Yeah,
purview, is
it's
that
my
right?
great privilege to announce that. I did
Excellent.
not have to bring that cart down here.
Isn't that
there.
wonderful?
Why is that, Cody? Why no cart, Cody?
We were able to go ahead and approve, based on the work of Mr. Lingerfeld and Mr. Kaufman in advance of the meeting, all of our existing applications. There's a number of PLSI. But I did receive a letter, I think last week, sometime after October, from a candidate who was denied in our July meeting, and he has asked for the board to take a second look and possibly, if necessary, to set up an appointment to meet with the board where he can explain his rationale. But I just thought very quickly while we had the opportunity. This is a PLS application. This gentleman took the FS, I want to say in the spring, and then turned around and applied to take the PS his particular path, Path 2, the bachelor's degree with the additional specific hours, as far as I know, stipulates that mandatory 2 years. Not sure that we have a way around that for him. I think it's related to what we were talking about, where maybe the path is not as clear as it should be. I think that's the issue, but I'll just let you guys take another look at it real quick.
Thank you very much.
Oh, yeah, I know it.
And
Yeah, you look at it, I know it.
That cover letter.
Yeah,
sure
he
it's
basically.
Issue.
Degree from a science, engineering, or technology curriculum, 4 more years. 4 semester hours. At that,
He should have applied under one because he graduated from ETSU.
Here he applied under one.
Yeah, he applied under
This thing
one.
says.
He
So-
And it wouldn't matter if he applied under one, two,
right, it's the
or
same. It's
three.
the same.
It's the same
I'm sorry.
result.
Here it
You're
is.
correct. It was path 1.
Okay, and the record satisfactory to the board of 2 years of progressive practical experience after the applicant passes the.
Bet you
That's
it's
clear as it gets.
Yeah.
What is the argument here?
Uh,
What is he saying that we're missing?
His
or-
argument is that he has
Progressive practical experience, is that, okay.
my position and responsibilities have been maxed out with my.
That says 2
The
years.
reasoning of
Yeah.
that is that for people who are applying.
Well, let me give you a little history. Several years back, when the FS was paper and pencil, this board allowed a potential graduate of a surveying school such as East Tennessee State University, where he had take the FS examination in their senior year, and passed it. It was fine. As soon as they graduated, they went to work. Well, 2 years after their graduation, for all intents and purposes, they were taking the PS and the TS and becoming licensed, which was the shortest path to becoming a licensed surveyor in the state of Tennessee. Well, that path no longer works because you now have to have your degree in order to do that. But that's where we're talking about the FS because of all these criteria. See, there's still some things, for example, the proving this FS, there's still some things in here that the candidate still has to meet after they pass.
Right.
So, so we're just trying to, we're helping them get the test out of the way.
Correct.
So they
And
can
not
kinda
standing
keep on
in the
moving.
middle of it.
Right,
So.
not
We
being in the middle.
changed
Right.
our current policy would help people like this.
Yeah.
Maybe, who could.
Well, but what happens to you there is if you change the policy, it shortens that window, and that's not the intent of the statute. I remember this gentleman has taken the exam a couple of times prior to passing, at least once, maybe prior, but that matters not. But, you know, the date of passing is what triggers the meeting, the meter for this right here.
For the 2 years, yeah.
Yep. Under my understanding of the rule.
So in essence, there's nothing new that we can consider to approve them, is that right? Okay.
I mean, I feel for the guy, don't get me wrong, but he's just going to have to be patient and get his 2 years.
See, here, this is what I was talking about. I knew that he had graduated sometime prior. He graduated in 2011.
Yep.
We're talking about 2016.
Yeah.
There's a 5 year, there's a 5 year window of time in
Yeah,
there.
he mentioned when he was in school that you could take them all.
Also acknowledges that he understands the rules have changed, Sam. So, I mean, he's a reasonable guy. He
He's a
sounds
good
very
kid.
reasonable.
I mean, I know him. He's a good kid.
He'll get his time.
File for me.
He'll get his time.
He wants that.
Our hands are tied there.
Talk about how you found doing it now.
You're talking about the
The
computer?
system.
Yeah.
Okay. Well, I can just tell you from my own experience. It worked, pretty much just like we had rehearsed on the previous meeting up on the big screen. I was able to drag the information, put it on my desktop, and read it that way. I did, just like you told us not to do, double-click it while it's on the FTP, and it comes up garbage. It comes up garbage, just like you said. I still did it. And but anyway, once I got around that part, my little issue there, I got past it. Was able to review them. No different than having the paper right here in front of me and going through them. Quite honestly, it was pretty easy.
IT, I guess it's not that bad.
I think once if we start adopting that towards the further examinations, it might get a little more challenging. Obviously, we've already had the discussion about plat reviews and all that. We're not going to jump into that again today. But I did have. I will say that I was looking for somewhere in the window the opportunity to put notes or pat on the back to Cody for doing a great job, et cetera, et cetera. Didn't find that until later on when I read your email again, that the opportunity was there just on a separate PDF file, which I did not utilize. I just sent.
We need to tweak that process a little bit.
It could be, yeah, it could be. But all in all, it worked just like you told us before. I didn't have any issues with it. Granted, the 3 applications that I looked at were fairly cut and dry. That made it certainly beneficial. But it does work. I didn't have any problems with it. Tim, issues on your part?
I've always got problems. But they're simple problems. They're simple
Okay,
problems.
good. You can do that.
I have trouble on my laptop reading the PDFs. I didn't feel like that they were super clear, but I mean they weren't dingy, but I have trouble, and it's awkward for me to have to blow it up because when it comes up on there, for example, my computer screen is landscape this way, and it comes up portrait this way, so it makes it even smaller. Well, then you got to blow it up, and that was a little problematic. Well, mine don't do that. I don't have one of them fancy ones. But that was a little problematic. But I mean, that was not unattainable by any means. The second thing I had was I had a comment on one of the applications. We had a reference form on one of the applications that the licensee drew a hand-drawn stamp, and I take great exception to that. To the point it's a violation of our standards. And I've made a comment on my form that needs to be corrected. I mean, to me that's childish. I mean, if you're a licensee and you can't get your stamp out of the drawer and stamp it on a piece of paper like our statute calls for,
You should have a stamp.
I got a problem with that. And like I say, I debated long and hard looking at that application of whether or not to file a complaint on that individual. So what I said in a kinder, gentler way was just simply, let's get this reissued with a proper stamp on it.
My view, it shouldn't hurt the candidate who had no idea that it was sent in this way.
I disagree with that.
And he did have more than the required licensed references, but we do need to treat that
Let me
maybe a little
question
differently.
that. It says 3 references, one of which may be a licensee. He only had 3 references. So if all 3 that he has are all licensees, he only met the minimum requirement. So the fact that he had 3 licensees does not say to me he had more. And the licensee, by not doing his due diligence properly on there, I got a problem with. I mean, that's just, I'm not saying anything against you, Cody, but I just have a problem with that. I mean, our statute clearly says all documents that we sign, we're supposed to seal.
I would suggest, and I don't want to hold up the applicant's application. Obviously, it's not their fault. But I would suggest a new reference form be sent to this surveyor
And
here.
that's what I put down.
With the opportunity to update
Right.
with a real stamped.
Right. I checked on my
copy
form. I
because,
checked
yeah.
deferred because the
I
reason
saw
I
that
checked
too.
deferred was because I wanted what Jay asked for.
Yeah.
And I think that was appropriate. Now, the last thing I wanted to say about the system was I could not, and again, it's probably because of my lack of computer knowledge, but I could not drag and drop from my desktop back into the program the form that I had just filled out. I could do it on my desktop. Matter of fact, I even PDF'd it and sent it directly to you, but I could not get it to go from my desktop back into the system.
I don't think it does.
Well,
But the instructions said so.
Yeah.
didn't they,
Yes?
Cody?
A PDF that you
we're
worked on,
gonna-
or?
yeah,
No, it's a form. That's
Okay.
the part. Each applicant has the application and then a form that the board makes comments, approves.
Right.
Well, it's that second form that, because they both go over to the desktop, and then you fill that second form out, and you're supposed to be able to drag and drop,
Right
put
back
it
in.
back into the system. I never could get it to do that.
well, that's on your third point. We'll work to simplify that. Hopefully, make sure that it works before next time. On the issue of the reference, we'll definitely get that taken care of. And then on your first point, I think honestly a lot of that has to do with resolution, and maybe something that we fix simply by updating our applications. I've done a number of new applications since I've been here for a variety of our programs. Making sure that they are legible is one of the important things, but we have not been able to do that with our surveyors because what you're looking at is a PDF of a photocopy of a scan of Donna's application
Yes.
from the 90s or whenever it was. And so when you start messing around with that, it's not
Horrible at best.
ideal.
And like I say, I knew you didn't have any control of that because I knew what you was working with. I'm just saying it would be great if it was a little more legible. And I think what we're going to discuss next will help us get there.
Absolutely,
I really
right,
do.
because then Cody will own those applications. We'll be able to really work them. Absolutely. So am I correct in understanding that of the 3 applicants that you all reviewed, where one is going to get a follow-up letter regarding the seal?
Yeah, now everything gets scanned to the file, so those references are going to be with that candidate in their file till the end of time. That's the way our new system's set up, so we want to make sure that when they go the right way, that they're done correctly.
No matter with what the
not
surveyor
his
did
fault.
as far as the
Right,
reference.
right.
But he took time and just drew a stamp in himself, and I just, that don't meet the statute. Sorry.
Okay, so we're covered with all 3 of those applications, plus the one that we reviewed here. We're all clear on the course of action for those? All right, any other application business? Cody? All right, I guess that covers that item on the agenda. We'll move on to the next one, the application revisions. Completely separate topic, though similar in nature. This was brought up at our last meeting about trying to, of course, in the overall picture of trying to make things more efficient and updated. Did we get a chance to look at the applications to see if there's anything in there that we need to update, modify, change? What are other states doing that we're not? What are we doing that they're not, et cetera, et cetera? I did get the chance to look at the FS applications for all the surrounding states from Tennessee. And literally, I highlighted the differences on there and made note of them, and I'll send you a report of what I found. I'll just kind of highlight some of the things that I found on those. The majority of the states, and this isn't all of them, but the majority of them required whether the applicant had ever been charged with a misdemeanor and or felony of any kind, and what the action was. Some of them excluded traffic violations, some of them did not. Some of them specifically included those, but they wanted basically the history of both misdemeanors and felonies. I think ours currently only relates to felonies, if I recall correctly. That's one suggested change. One state that I did review, I thought this was interesting, was I think it was California's. They required fingerprint records of the applicant, and they did full background checks on all the applicants. I thought that was interesting. I don't know that I'm quite in favor of all that, but I thought that was interesting. That was unique to them. No one else was doing those
Probably in their code, and maybe due to something having happened to trigger that.
It may be, yeah. There was something there.
Yeah.
Some of them addressed military service. I know that I think we have a fairly recent rule in there about military service.
Across the board for every, yes. To expedite, yeah.
It was, yeah. Especially if they had recently been transferred in or only anticipated being in the area for a limited amount of time. That was interesting. Some of them went into some of the more minor details about, place of birth. Certainly, the things I did find in common certainly was the list of education, the list of experience, the reference forms, things like that. All of them were generally the same in nature. What I appreciated in having reviewed so many of the states was some of them were very brief, which kind of caught my attention. I was like, wow, that's all they're looking for, but it covered the basics, the basics of what an applicant needs to convey to a board for an application was there. And again, I'm only addressing the FS exam. I did not look at the other applications.
Right.
So I thought that was unique, and certainly something I thought that if we do get down to revising these applications or looking them over, that's something to keep in mind. Just to keep them as brief and short to cover the necessary information that we need and not go into long narrative details about things that really don't matter much.
You make a great point, because as we've moved to our new computer system and put things online, many of us had 8-page applications. I mean, just long applications. And the question we have to keep asking ourselves is, what do you need to do with this information? Because if you're just asking to ask it, there's no place to really put it. Sometimes it creates more problems than it's worth. So I think that's a great point on trying to make it simple.
There was one issue, Laura, I might want to address this with you or someone else in legal. There was an issue with a long narrative about the applicant's Social Security number that was put on there. I believe ours currently asks for it. I think most of them probably do, just to be able to identify it. But the narrative that they had in there was trying to explain, number one, that the use of the Social Security number was confidential, to be kept within their internal records. However, it would be relayed onto the central database for if anyone ever had legal action taken against them, like child support issues, things like that the opportunity to remove that applicant's license because they're not paying things like child support was there. And it was explaining that in detail, which I thought was a pretty good thing. I don't know what the state of Tennessee does in that terms, if they can come after your professional license. I think they can.
We do.
I think they do.
You
Yeah.
don't pay your student loans, or you don't pay child support.
There was a couple things.
We had that several years ago come before the board.
I thought, yeah.
Most common one are student loans and child support. If you don't pay those, letter from
those agencies, and we have to carry it out, and we have to suspend them.
Right.
And then we do deal with now what do I do? Well, you pay child support and you pay your student loans. As soon as they unsuspend you and make it right, we release your license. You become,
I just
we're
thought
the
it was
same. We have to
interesting
ask
it
for
was there.
social security number. But we don't release anyone's social security number outside of this.
I have in my hand, and I've never been one to say a lot of nice things about. I have in my hand an application that she crafted about our discussions about this before, because we have been working on this for a pretty good period of time. And it's about as short with the paperwork that's required because of this. It's 10 pages, but 4 pages deals with your citizenship of the 10. So I don't know, Ms. Roxanne, if you have this, but I'll be glad to give you my copy of it. I think it's pretty much to the point. It's pretty clean. It's different than the one that we have on the website. It's not that one. It's this one. And in addressing Jay's comment earlier, we talked about this before when she was here. She put questions on there relative to convicted of a criminal offense in the last 5 years. So I don't know why it was repeated twice, but it was on there. Because we had never actually formally marked this one up.
Okay.
We were close, and I don't know if it was because she's no longer with us or some other reason that we stopped. But I'd like to give it to you and let you take a look at it, because I'm sure somewhere it's on, the website, your all's website, or within your all's interdepartmental stuff or whatever, so you could find it. And like I say, it's pretty clean. I'm sure Cody's seen it. He may have even did it. So I like he's shaking his head up and down, so he's probably did it. So I should give Cody proper
Yes,
credit
yes.
also.
So Cody, of these, I don't have that one, the FS, right? We've only got the other two.
So,
Okay.
And this, if I remember right, we started talking about this one when we were talking about the non-approval necessary for the FS exam.
Okay.
And like I say, this one's pretty clean. It's pretty generic, very basic. Doesn't really ask a tremendous amount of questions. Would not take any time to fill out. Would be really less time than the other. The one thing I miss on all of them, and I know if Sue was here today, she would say the same thing. Miss the pictures, because we always had a picture in our application for years and years and years and years.
I'd like to bring that back.
It'd be nice, but I'm sure there's probably some employment law that says we can't.
Oh, not necessarily. Now, it delays the process because you'll be surprised how often people forget to send in their photo. And remember that we scan everything now, so the photo doesn't always look that great scanned in.
Some of the photos we got didn't look that great either.
Okay.
That's what Sue always said.
Yeah, that's what she said. Yeah, Sue was in charge of photos.
That's great.
Yeah.
That's
Let me ask you a question on the current application. I think I know the answer. I just want to get it clarified. The transcripts that they submit, are they official transcripts that are sealed when they get delivered, or are they just happen to pull out a set of transcripts and throw it in with the application? Because I can tell you every other state here is official sealed transcripts
From
mailed
the school.
directly from the school.
Yes.
Right.
Do we know what our current status is on that?
At this point, it's very difficult to determine.
Okay, I think
because
we probably need to update that
everything
to be
that
official.
gets mailed into us, if it's in the packet, for example, if sealed certified transcripts come to us in the application, then they go to the mailroom. The mailroom rips it open, scans it, and gives it all to us electronically in our licensing system. So at that point, I can't tell if they came to us like that, or if they came to us sealed. Now,
But the envelope is addressed to us. Or should be.
Gets thrown away.
Okay. We can ask for the envelope to be scanned, because
Yeah,
I have
we
the
can
same need with other boards, and yes.
We can redo that, and most of the time it's not a problem because those are coming directly from the institution, and so they'll come to our office. But whenever they are included with the application packet, then it's scanned and we never touch hands on it.
If it's not already, then I think the application should clearly state official transcripts.
Now, in the current application, Jay, it says college graduates must submit certified transcripts.
Yes, but that's different than being.
A high school graduate.
No, I'm saying that's, I can order a set of transcripts, have them mailed to my house, open them up, do whatever hocus pocus I need to do to it, and then send it to the board. And that's a certified.
That's a certified.
Certified because it says certified on it, but I opened it. What I'm saying is the transcripts need to come directly from the institution to here. And I think that's kind of standard, really. I was kind of surprised that it wasn't that way already. So I don't think I'm asking for too much. I think it's kind of standard.
And add that language. Exactly what Cody said is true, though. We will make sure that when they come directly to us, if they're not part of the application, they really then are delivered in an envelope and we touch them. if for some reason there's confusion, mistake, and they go to the applicant and they haven't opened them and they come through the application, we'll make sure that the envelope's kept. And at that point, the best thing we can do is assume that if the envelope was addressed to us, that it was sealed and not touched.
That's also the way that you should get out-of-state license verification
Right.
also.
That's exactly what I was thinking of.
Now,
Yes.
Now, the fly in the ointment in that is the NCAAS record, which I personally don't like because people don't keep it up. They get it set when they submit it, and then they just never keep it up. We had one a couple of years ago that the last time that the NCAAS report to us had been updated was in '06. And we had knowledge of this individual that had applied for licensure that had complaints since '06, out of state. So, that was one of the things we had to force him to get his NCAAS record updated before we could review it.
Is that record kind of like a letter of good standing that they send? Is it something?
What it amounts to is NCAAS is a repository for your professional license record, okay?
Okay.
In other words, it would have your college degree, your work experience, any other licenses that you may have, any disciplinary action. See, that's something, for example, if we discipline someone in Tennessee, I hope that your staff notifies NCAAS so they can notify the other states with that registry for that. But the record includes all of these things. And when, let's say I apply for Mississippi or something, if I have an NCAAS record, I just notify them, and because I pay them an annual fee to keep my record, they just shoot a copy right over to Mississippi, and that goes with my application, and that's supposed to be all the facts and history about me. Well, if I've not updated it, everything's not up to date. So I really, when we have applications from out-of-state folks that are for licensure in our state, I really don't like seeing an NCAAS record because they're cumbersome to go through. They don't really fill out the application that, where it says experience or education or any of those things. And oftentimes they even include references in them. And the references may in fact be old. And they'll just put, see NCAAS record. So those are a little problematic for us. I wish that we didn't accept them, but we do, and that's the way it is.
Tim, would you expect someone that is applying through Tennessee for the FS examination?
The FS?
Yeah, that's the only one I was talking about today on the application was the FS.
They could from the, you mean an NCAAS record?
Record.
Okay, not a number.
No.
Okay. A record, I would say no.
I would say no as well.
I would say no.
Yeah, I would say no as well.
For the license, yes.
Yeah, absolutely. Okay.
But atypically, that would also only be someone that is already licensed. It would not be someone that is yet to be licensed. Because once you
Makes sense.
get
That helps
licensed,
me, yeah.
that's when you'd want to fill out the NCAAS record and have it on board down there in their repository so that you could add to it, ship it out. If you were a young guy or girl and you're just getting your license the first time and you knew you were going to apply in 4 or 5 states because you worked for a big multinational company or something, you'd want to do that record and get it all sent in, pay your fees, and then every time you did an application, you just point that to them because it would already have everything you needed in it. So, I can see the advantage of it, but if it's not updated, it is cumbersome.
Cody has printed the application for the professional land surveyor that we have online and the land surveyor in training. We can talk about them. I like starting with the FS because if we can clean that one and
Do it step by step. If we try to mix
I
it
agree.
all
And
in,
you all
it's too
can take
confusing.
these home since they're printed. That may not be a bad idea
He
for
sent
us to
them
keep
to
working.
us
You got them electronically,
our
too.
agenda email, Martha Cody, because that's where I printed mine from.
Yeah.
Was the agenda email. But like I say, the rest of them look at this if they don't have it with them or remember it. I know Miss Betsy wouldn't because she hadn't seen it. But this and Cody worked on this. It's a pretty good.
It's good to go.
Pretty good shot. Yeah. There's a few little tweaky things, couple of things, but it's pretty close in my mind.
Great. I think that's great.
Or
And
we,
the-
you know, and I mean, I went through and made some marks on a few of these and so forth, if we want to discuss them or whatever. I'm more than willing to do so.
completely up to you all how far we want to go, so that if we want to touch on the new business as well, and I've got your letter back signed, so this is in my hands. This is perfect. So it's totally up to you.
Okay, did we want to go anything further on that today, or do we want to?
If
Review it
that
and
has
send it-
some, I think if we've reviewed it and it's got some changes, I'll be happy to update it. I know I'll find on Nicole's Drive, and the team's got a wonderful way of sharing documents, so we'll find it, we'll tweak it. I can send it them back out through email to everybody with a few changes, and if you've marked on them, Mr. Lingerfield, Mr.
Actually, I hadn't marked on that one.
Mark away anything you think needs to be taken out. And you are right on the piece that has to do with the verification of your status, whether you're a U.S. citizen or not. That applies to every application. So yes, in many cases, we separate it, but when you do, then they forget it. So when you put it in there and you've got 2 extra pages, that's still understandable, but at least then we know we've looked at it and we've got the FS in good motion. The other applications you can take with you, and we can just keep cleaning these up.
Okay, what I'm going to suggest here is just kind of leave this on the desk here. Let's go ahead and address
Perfect.
the additional items we have on the
Perfect.
agenda. If we still have time at the end of the day after we've covered the items of the agenda, we can sit down and go over these things and get them to you.
Great.
Just in the interest of not sitting here and reviewing it while we're.
Absolutely, that sounds perfect.
Okay, so we're going to move on to new business. First item, the Southern Zone 2017 update. I imagine that might have had something to do with the travel expenses. Was that what that was?
Yes.
One time, the NCAAS was funding 2 delegates. They changed it to 3 delegates, but there was some question as to whether there were some restrictions, being that it was outside the continental U.S. Is that right?
Yeah.
I think we thought that there may be some restrictions from the state on board members traveling outside, and we just want to get some clarification on that.
I think as long as they've selected their location, and in this case it's a U.S. territory, we're going to look at their bylaws to make sure what it is that they're paying, and if the board wants a vote on who is going, then we can proceed.
So we don't know of any restrictions of any kind on any of that.
Not as long as that's where they're having your conference, your meeting.
That is scheduled for what month?
It's April.
Probably if we,
27th.
when we convene back at the January meeting, if we have those.
Well,
We'll have, and Laura said that I think we already voted on it in October, which
we
that's
voted for
leaving my
Mr.
mind.
Kaufman.
Perfect.
But didn't vote for anyone else. And also the paperwork they gave us wanted us to try to make sure to have everybody kind of lined up in place who could potentially go, because they may need to do some early registration because of where it's at and so forth. That was what they asked us to do in the Southern Zone meeting.
They give us specific dates as to when that information had to be to them.
Well, their target date, it says a firm response from for funded defecating those amendments go out to the boards in both zones mid-November, so which means you should get them in a couple of weeks.
I haven't
know.
gotten a deadline.
And then
from
it
them
says
yet.
a firm response deadline of February the 1st. That's what they told us. So, we need to be able to tell them.
April 27 meeting?
Yes, ma'am. Yes, ma'am.
Okay, so the firm response by February 1st? Is that
First,
what that
yes.
should- Okay, so,
Yes.
and it sounds like we have not heard anything from NCAAS yet? Is that
Not
right?
yet.
Okay. So we do have some time that we can come back here in the January meeting, firm up exactly what's going to go on and still meet the
Right.
the hard deadline of February 1st.
And they will
hopefully
probably
get some
ask,
information by then.
who do you expect?
Yep.
And which I feel like we can tell them, basically. We're probably going to send.
Okay. Okay. Was there any other updates on that? Okay, good. All right, the second item listed in new business, the drones used in surveying and mapping. This is kind of a timely topic on my part. We've had some, in the Memphis area, at least I can speak on that. In the Memphis area, we've recently had a firm offer services with the use of a drone. In fact, they had submitted a proposal for professional services with the use of a drone. They were very detailed in that they were using the drone. Basically, they were marketing their services that they are state of the art et cetera, et cetera. So it's kind of very timely in that we were after the same project. Of course, we don't have access to the use of drones at this time. But it came under the aspect, my question was that part of what they were offering to do using these tools, the drones, was to perform some volume calculations. However, as best to my knowledge, the firm was not working under the license of a professional surveyor. And so that was where I kind of went, whoa, wait a minute. But it made me think at one point about the use of drones in that I think just like any other tool in the toolbox that surveyors use, be it a total station or plumb bob and chain or GPS or whatever, that it is a tool used for specific situations that the surveyor deems is the best project and scope. But what I want to make sure that we don't do is try to regulate the tool itself as opposed to regulate either the product or the use of the tool. And of course with drones it's a whole nother world in terms of regulation from the FAA and the use of drones and blah, blah, blah. It's a whole other topic that really I don't think we need to go into other than saying that if they use the drones during professional surveying efforts, that it's used under the guise and full regulation of the FAA and leave that onus on them completely and not on this board, because that's not our decision whatsoever. I think that's important. But as far as the tool itself, I don't think, just like the other tools, that we should be in the business of regulating their tools, how they use it, or even, to that matter, even certain specifications, but rather the product that the tool produces. In this case, generally speaking, the use of drones, you're going to produce either a point cloud or a series of photographs for the use of photogrammetry, which certainly does, in my opinion, fall under the guise of surveying. And so that's where I wanted to kind of bring this topic out and generate some discussion on y'all's part as far as with either the regulations that we already currently have in place, whether it be under general surveys or under remote sensing or whatever, and how these tools, in this case the drones, are used, and to what jurisdiction do we have over the product that the drones are producing, as opposed to what jurisdiction do we have over the drone itself, which I really think we need to get our hands off of. That's not our business. The tool they use is their business. Any regulation with the FAA is their business. We really need to stay out of that. But the product produced as a professional product, if it's being represented as a survey or mapping that falls under our jurisdiction, and how do we recognize that, and how do we best go after that? I would be shy. I'm handing you a big softball.
Betsy says I talk too much, and she's right. She didn't say that. She didn't say that. Well, Mr. Kaufman, before you came on the board, we did these terrible things called policies. And we actually still have about 8 or 9 of them that exist, believe it or not.
Yes, we do.
I'm shocked that they've hung around and haven't got zapped into cyberspace. But we have a board policy regarding digital terrain modeling and GPS. And primarily, the use of the tool of a drone, in my mind, is very similar to what falls underneath that domain. And I think you're exactly right. It's not ours to regulate the tool, whether it's blue, green, or purple, or flies upside down or right side up. But when a product is developed for the public, if that product is normally developed within the definition of a practice of a land surveyor, then that product needs to be so tied to that surveyor or a surveyor, as far as certifying that, this is information is correct, et cetera, et cetera. So it's my opinion that somehow or another we need to expand our policy to include the possibility of adding the word, and I would prefer to use UAS, unmanned aerial systems.
Yep.
Drone is more of an acronym for them, so that everybody knows what it is.
That's right.
But I would prefer to use the UAS so that we're able to add that into this policy scenario and let the registrants know and the public know that we take very seriously the product that an individual using a UAS is producing. I think that's where I would like to see it handled right now, because I've been a proponent for years that we ought to have photogrammetrist license in the state of Tennessee, and if we did so, this discussion would be a little bit muted and not supported. So that's kind of my take on it. I don't know. What do you think, Mr. Northcutt?
I'm in agreement with Jay, and you. I'm not. Well, that's the product that we have to turn out, and we regulate as a plant stamp that goes on there. That's my liability. That's his liability that he puts his stamp on, whatever he is turned out. And and I realize that we had these policies, and for whatever reason, if
what is it that you want this policy to do?
The policy that we currently have for DTMs and GPS, I'm on my acronyms now, I would just simply like it to include UAS. And I think it's appropriate because they all wear the same set of shoes.
and they do the same thing all
Right.
Right now, we have rules for GPS used in land surveying, and that's in the process. It's with the Attorney General's office. So the policy discussion, and I don't want this to feel controversial or heated or anything. Policies are fine. What we can't have is a policy that we cite to when requiring someone to have a license.
We've been beat up on that hard by
And
two
not
prior
just you.
attorneys
If
and a
it
prior
makes you feel
director.
any better, not just you, but it's not that we can't have policies. It's just there are certain places where if we're going to deny a license, or if we're going to tell someone that they're required to have a license, we need more grounds for that than a policy.
Well-
What I think you're all are saying is that the definition of the practice of land surveying is really the crux of what this board regulates. Whether or not somebody uses a drone to engage in these practices is sort of irrelevant. If somebody is doing anything that falls within this chapter, then they should be a licensed land surveyor. And I don't think we have to get into the nitty-gritty of exactly what you're saying, what tools they're using to get there. So I'm not sure if we need a policy to let people know.
I think I'm not disagreeing with you at all. Everything you just said was put a whole lot better than I ever could dream of saying. I think the reason that I support a policy here is for clarification. The whole UAS/drone, whatever you want to call it these days, 100 acronyms for the same thing, is new. And it's the shiny car out there on the showroom floor right now, and some firms are starting to jump into that. And some people are not seeing the connection that, hey, I'm using a drone and I'm gathering these photographs or these point clouds and I'm calculating volumes, et cetera, but they're missing the whole point that you're now under the purview of, by definition, surveying. So I think what we're after is we have the mechanism already based on the definition, just like you said, exactly. It's there. What I'm asking for is a clarification in writing, which I think a board policy suffices for, that, hey, we're including.
More of a policy about educating the public.
Correct. A lot of that, yeah.
Correct.
Absolutely.
We're not so the idea is education, that we're not attempting to overstep boundaries with drones. We're just reminding everyone that this is the definition of land surveying, and regardless of how you get there.
And I think by putting it in policy shows, as opposed to in a newsletter or a website or something like that, by putting it in policy means that this board recognizes it, is addressing it as we recognize the tool, not trying to regulate the tool. We're trying to emphasize that the product could be used or could be under the definition of surveying, and that we recognize it, and that if it comes to the point, we will enforce the rules as they're I feel personally why I think policy is where this belongs, because it's not, already have the rules. The rules are there. But at the same time, just casual, website, newsletter stuff isn't strong.
They different from our GPS rules that are at the AGs or wherever they're at. The way our standards of practice required us to have those things, and we didn't have those. So this is different. They said it very aptly, and you did too, Ms. Martin. And because at the bottom of the board policy, it says that what we're talking about here is within the definition of the practice of land surveying and shall be performed only under the responsible charge of a licensed professional land surveyor. And that's all we're saying. It's sort of an FYI to either the registrant or the public, but more so the public, so that the public is aware that if you seek out this product that falls within the definition of surveying, your result that you get back should have a registrant's sign and seal on it. That's all we're saying. We clearly understand, and we have been browbeat to death, particularly me when I was the chair, about the fact that you all could not adjudicate a policy. I understood that. I understand it, but we can adjudicate a rule, if we got a problem, but not a policy. But on a day-to-day basis, I get a lot of questions about this. Just like Jay had a question about a volumetric situation. I get a lot of questions, and no, we can't tell them what they can buy or which one or anything like that. Yes, we can encourage somebody to make sure that they clearly follow the FAA rules, because there's severe penalties if they don't. But thirdly, I tell all of them, you need to see what your product you're producing to determine whether it's surveying or not. If it is, you better have a surveyor.
So this board has the exclusive authority to interpret their own statutes. I think that the best thing we can do here is let me do a little research to figure out what the proper process is here, but I don't see any reason why we couldn't bring you a language statement of clarification, have the board approve it, and then I can find out the best way where to publish that, the right method that we can do that. But that's something that we can work towards, as long as and I know you're saying, for the record, just as long as we know we're not attempting to expand anything, we're just trying to go ahead and clarify something that you all apparently are getting a lot of questions on.
And a little different from Jay, I think the newsletter is a reasonable form.
It is.
The website on frequently asked questions is a reasonable form.
All of those, if we're talking about education.
Any way that we can either better educate a registrant, or we can provide information to the general public, which is our sole mission, then I think it's positive. And clearly, without trying to us reach out and embellish everything and say, hey, we want to be in charge of that. That's not what we want to do. We just want to say, pay attention to.
Okay, at the next meeting then, what I'm going to do is I'm going to try to take all of this and put it into like one concise statement of clarification. Just so that I know that we're above board about this the best way possible. But as long as if you're attempting to interpret your own statutes, then I think that we're.
If I recall, isn't there on our website currently a list of the policies?
Yes.
Board policies? I think so. I
It
mean,
was.
we have. Yeah, I don't know if it is today. I know not too long ago. I remember pulling them up. I think there was 9. I think if I remember right.
Yeah, we pared those down. We
Boards
did have
are
about 20
allowed to
that
have
didn't
policies, but because policies are so easy to create, boards preferred to create policies instead of rules. So things that needed to be in rules were becoming policies, but we're not doing that anymore.
Just like one of our policies is a history on surveyors and drainage, and it predominantly has the AG's opinion from 2004 in it.
Exactly.
Which I don't agree with, but that's neither here nor there. That's another subject for another day.
Let me ask you this, Laura, just straight up, as far as the policies that we have published on the website, et cetera, are out. Your opinion that's it for policies? We're not going to issue or modify policies from here on? Is that what you're saying?
No, I think that.
Because my suggestion with like Tim was, let's just modify this policy, include the word UAS. I'm good to go. Let's go home. I know that's extremely simplistic, and I'm making it sound way simpler than it is. I'm just asking, is that an avenue that we
That's
can
an
pursue?
avenue. I just, without, like, it's not that we're doing away with policies. I think that there has been we're allowed to have policies. We just aren't allowed to have them in place of things that need to be rules.
Right. And that's what I
So that's fine. So it's not as if policies are a bad thing, as long as we're creating policies for things that are appropriate to have policies.
I mean, to me, I liken it just like Ms. Roxanne's presentation to the TAPS board. You know, she went over to educate them on the exam process and things that, you know, she felt like they needed to know, and it was wonderful. They were invaluable. And that's kind of what we're doing here, is we're trying to make sure that I feel like that we're remiss if we don't try from time to time to help educate the registrants and the public about who surveyors are and what we do and how we should do it type thing. Because the better knowledge that they have, just exactly like the complaint we had today on the lady and the $325. That is a communication fault, probably by both parties. But clearly the lady didn't know what to ask, and the surveyor stopped short of asking any more questions himself. So anytime I feel like that we can educate the public and the profession into these things, I think it's very valuable.
I will read the existing policy, and if you I can come back to the next meeting with an answer on whether or not I think we should just have a new one. But either way, I'll need the board.
Certainly want you to be comfortable with it first,
Okay.
and certainly don't want you to
Yeah,
overstep
we're not
anybody's
asking for you
bounds.
to create a whole new library of stuff back here somebody can go search through. We want to keep it simple too, you know.
It could be that when we updated the websites, because now every board's website is pretty much identical, your documents, that policy thing isn't there. I don't remember seeing it, but it's very likely that if it's there, we'll pull it. If not, we'll definitely have a version of it. We'll just, and then use this statement if we can, either on the next newsletter or the following, but just hit that education piece every way we can, because I think that's vital.
Great, thank you. Okay, any further discussion on those at all? Anybody? Okay. All right, that covers all the items that were on the agenda. Certainly want to open the floor to anybody here, staff included, if there's any additional items that they wanted to bring to our attention or have discussion on.
Can I ask a couple questions about the website? Maybe Cody or Miss Roxanne, whichever. I wrote these down while I was going through it the other day. I was looking over the application stuff, just kind of thumbing through it. I don't do that very often, but I found it curious that we had an online complaint response form. So a respondent can actually reply. I just want to make sure I understood that.
And I can answer that. So the complaint process for all of the regulatory boards has started to phase into being centralized. So there's a lot of the boards have already rolled to it. That means that when that complaint form comes in, even though if I'm a surveyor, I might just have the shortcut to the Surveyors board and never realize that all 33 other boards are identical. But if I get there, or to any of the other boards, or for that matter through insurance, consumer affairs, that complaint form is now identical to all the boards. And the reason they've added the response form is really so that if the respondent is ready to answer, and they should, and we always guide them and say, please put your response in writing, because we'll get it on the phone, or we'll get a fax and you only get one of the 3 pages. So if you need to put it in writing, you don't have to use that response form, but it's there. So if they respond using that automated form, it comes automatically to the right form, to the right area, to the right, and it's not floating. And so it's at their ease. It's just to make it easier. But that is a brand new thing you found. So it's out there now. Yes, yes.
The other thing I had was, I wonder why that the continuing education is not tied. And the reason I ask that is that's a two-edged sword. When we renew at the end of every odd year, there's two criteria. And this is something I have a little pet peeve about. There's two criteria we have to do. We have to submit our fee, and we have to submit our continuing education. However, and this is a fallacy, I think, in our rules, if we do not submit our fee, there's a $20 a month penalty that will last up to a year before I lose my license. But I can submit my continuing education with no fee, and I'm licensed. I can submit my continuing education with no fee payment, and I'm licensed by statute. If I read it right, Ms. Martin can certainly correct me. If I read that right, because the statute says for every month that the fee is late, you pay a $20 fine. Therefore, I can be licensed for an entire year simply because I had the proper continuing education, and then I could pay my fee at December of the next year if I wanted to, before my year ran out.
But your fee's expired. We didn't send you a new license. Or your license is expired. We didn't send you a
Not
new
expired, not by statute. It's supposed to be, but it's not. If I read that right, I'd have to go back and look at it, but maybe I said that wrong. Maybe the license did expire, and you don't get it until you renew. Maybe
that is the way it works.
That's the way it's supposed to be.
We accept your continuing education, and Cody will stop me if I'm wrong. We accept your continuing education as you do it, with the thought that if you took a class in March, you can submit it, and you took one in June, and so forth. But your license will not go out with the new date for the next 2 years expiration timeline until you have paid the renewal fee and any of the $20, depending on how late you're running.
So what you're telling me is the individual is not licensed.
Correct.
If they've not paid.
Correct. We're accepting those continuing education credits, right? Because we don't want you to have to take them on the last day.
And the interpretation of that then would be that you have the 1 year to
Still
pay that,
complete,
and you're
yes.
still active. I mean, you're still
Expired.
eligible.
Yeah, you're still eligible. That's it. We
still
call it you're in a grace period. Is kind of how we think.
There's actually a little
But
blurb
you're not
about
licensed.
that.
Well, now,
Correct.
here's the problem that I do have with that.
Okay.
Because every time we renew, we have a bunch of people that don't do exactly. They do exactly what I'm talking about. They'll send their continuing ed in, or they'll send their money in and not their continuing ed.
You don't do the two pieces together.
Yeah, they don't get the two pieces together.
Okay.
And they're on this roll, you know. So, you know, and we've had issues with that. You know, well, I don't know what the list was off the last period, but there were several on it that did not meet that requirement. And we don't find out about those usually until our second meeting of the year. And there's a lot of those people, some of which I have known, have actually practiced because they hadn't got everything sent in. I mean, I just want to kind of flag that because to me that seems to be a problem.
And the statute probably addresses it, but it does sound like it's not extremely crystal clear. It probably lets you take the continuing education as your time is free to do, right? So you've got the 2-year period
2 years
under
to
which,
do it.
and that's similar with many boards.
Right.
And you don't want to take that flexibility away. You want them to have those 2 years. When you renew online, have any of you renewed online? Is it not clear in the language online? Because what it should say, and I'll test it, is your license, your new license for renewal will not go out until your continuing education requirement has been met and all the fees have been paid.
I don't recall.
Okay.
It's been a while now.
Okay.
Obviously.
Yeah, because that language then would clarify that these are those two pieces. If by chance you
I just
thought,
wanted to make sure
Okay.
because I struggled in the way that I read that. I didn't want somebody to be allowed to practice, but they weren't following the rule.
yeah, no, in essence, they've got an expired license. There's no doubt about that. But we'll look and see if we can definitely the online piece make it clear. And we're moving more and more to hope folks that renew online, and at which point they can attach a continuing education thing that they've got a certificate for, and hopefully we've received it directly already, but they can definitely tie those pieces together at the time they renew.
Because I remember mentioning the last time we went through this about people that that did not meet the criteria by the deadline, that their home county register of deeds should be made aware that they are not licensed. That's a person that's going to see a lot of their practice is going to be that register of deeds. In other words, if you lived in Sullivan County, like I practice in, it would go to Bluntman, so that they would know that, look, Tim Lingerfeld's not licensed, and I take a plat of her to get recorded. They're like, of course they'll record it because the register's law, what it is, but they'll know that I'm not licensed.
And currently, am I correct, we don't send lists of who's not licensed, who didn't
I
renew.
think the only time that we send that right now is when a license is revoked.
Right.
I think that's the only time we currently send it.
Yeah.
I heard we don't send anything
Yeah,
out.
from the
It's
volume
not our-
perspective, yeah, it's really then the licensee should know they shouldn't work because they're not licensed.
So when I read the rules about continuing education, it says that you have to send in your your PDH, proof of PDHs as a prerequisite. And then I think the section you were thinking about was the reinstatement from an inactive license to an active registration.
I was talking about the tie together of paying the fee at that time, but not actually paying the fee.
Right. But what I'm saying is it wouldn't automatically make your license active. Plus, isn't there an inactive license status that you can choose to
Have an inactive license.
So that's kind of different because you're not paying like penalties fees because you've chosen to go inactive for a period of time. But that's the one where once you pay a $25 fee and turning your PDH,
The only difference between inactive and active is that you don't do the continuing education. You still pay the fee. Right, you're not practicing.
But that's different than an expired license.
Right, that's different.
Okay. I'm saying our rules allow us to deny someone who's turned in their PD. Our rules still allow us to deny renewing a license even if you've turned in all your continuing education if you haven't fulfilled your other renewal obligations.
Right, you have two obligations, right?
Because it says as a prerequisite to renewal, which basically says you have to complete this, but this isn't the whole.
That's why I wish that we had renewals in 2 calendar years, so that your staff would not be inundated with 1,100 renewals at the end of every odd year. Wow. Because everybody knows as well that they're going to wait the last 2 weeks to get it sent in.
Right. And
Hi,
what,
Cody? How you feeling there, Cody?
Yeah, it's not fun.
the good thing is that by then our processes in core in the new system and our online system, if you will hopefully be at a point where what we're doing, because we've got a large group in one of the other boards that's about to renew, and so we're not going to send a paper renewal form identical to everything else. We're really going to say you're renewing online now. And so what we can do with the land surveyors is send them the letter, send email notifications, send some blast information way in advance. And so you're about to expire in 3 months, kind of go ahead of the dates that because I don't think your statute forces us to wait until that 60-day period. I think we can be a little bit ahead of it and say, here's how you're going to do it online. And by the way, make sure all your continuing education has been met and cover it that way. So that hopefully if we don't have a 60% online renewal or haven't in the past, we will with this new system. We can really push almost all of it to be met to where if your continuing education credits are there, then the license and the fees paid could automatically go out. That is what we're shooting for because you don't have anything else. We're not checking criminal background. The picture doesn't need to be submitted, anything else.
Do you know what percentage we had register online last time? In 10 to 15?
Last time our website went up, not a lot. It had just gone live, yeah. And I'm not even sure we sent out the 30-day because at that time we were transitioning between. I don't know if you guys even got notices because 30 days out we were in a dark period where we didn't even have a licensing system. And then that fall the website went up. If you could get it to work but a lot of people had issues with it, and so it was not as frequent as the traditional paper or email.
I think way in advance of because this profession, I think this profession is going to have huge success renewing online. I really do. So it's up to us to do the education through the newsletter, to go and speak at the TAPs, to remind everyone at the meeting, here's what you're going to do. They can register in advance so that if the continuing education's in there and everyone gets ahead of it, when they pay online, that license could, in theory, go out the next day and not even need to be touched. That would be phenomenal.
What killed it the first time was that $7.95 fee.
Yeah, there's no fee now.
I
Oh, well,
know,
there is.
that's what
We're
killed the first
absorbing
time.
it. Yes. No, I agree with you. And
That's
every
the
board
big
felt
bonus that we
It
sold
is.
people on with renewing online now is that you don't have a processing fee. Yes, it's a little bit of a pain to register for the first time.
Yes.
But hopefully a lot of people have done that by now. And our system will have smoothed out its wrinkles by 2017 for sure. And I'm getting a ton of CE right now. I got 6 emails from one guy this morning, people that are just used to annual reporting, and I'm thankful for that because it makes it easier this time
So
next year.
could we go on the website at any time and report the CEs, or do we need to still mail them to you?
I don't think as it stands, the core site will allow you to upload your continuing education as of right now. Yeah, on the continuing education reporting form is my email address. So when you click that, it pops up a box to send me an email. And then you just attach it and send it in.
But you bring up a great point. So one of the things with that first time you register to go online is the licensee pool already exists in our side of the world. You're missing a magical number that's going to identify to let you in, besides your license that you know and you know your address. So when we send out the renewals, we kind of give you what we call, it's an original individual number. It's that entity number that ties you in. We're going to give that to you by paper. But I think with the numbers and it being in 2017 and we've worked out some kinks, it would be ideal to be able to register as many in advance as possible to where maybe even then you can go online and drop in your continuing education, because we're finding with other boards that they're dropping in, for example, the Athletic Commission, they're dropping in blood samples and all these other medical forms in their file way before they decide to get that license and even after. So if we can start working on some of those things and think of a way, so it's got me thinking of where we can get our applicants to go online and start dropping their own continuing education in. That would make Cody's life easier, but more importantly, it'd get us used to the online system. So when it's time to pay, you're just going in that night and paying.
And see that, I'm thinking too, while you're talking, that would be a good 5-minute presentation at TAPS. Because
Absolutely.
you're sitting there and you got 350 surveyors in the room, and then they're associated with other surveyors that either work for them or in the neighborhood or whatever. You get the message out pretty fast.
What is that magical expiration date for you all?
December 31st of every odd year.
Odd year. Okay.
2017 is our.
I probably forgot about it because it's way out there, but absolutely. If we can get some of these automated processes, and as we speak and do the newsletter, and we can say, you can't pay and renew right now, but did you know you can go ahead and register and do this, and then we'll kick back your number and get you acquainted with the site and drop in your continuing education. That would be
That's
fantastic.
something I want to attack early and often.
Oh, we are.
I mean, that would be invaluable to Cody and the rest of the staff.
Absolutely.
And again, getting it out like newsletter, et cetera. Maybe you send it out early in the year, maybe then you send it out later in the year in a newsletter, just as a FYI for everybody.
Yes.
And then that may make your all's job a little easier, and then the numbers may go up as well.
Well, they will. Yeah, without a doubt.
Last year, Donna left at the end of the summer. We had the tremendous transition with the file system and everything. We just didn't handle the renewals as well as we could. We ended up hiring some temporary to handle the sheer volume. So we need to probably be a little smarter about it. And I think with
even to the extent of simply saying that if these items are not complete by December 31st, your license is expired.
Well, and it is.
And
That's
I mean-
100% accurate, yeah.
But surveyors need to
Push
hear
it.
that.
Yeah. Oh,
They
absolutely.
need to hear that. Even though
Absolutely.
it's fact, it's not being cruel, it's just a fact.
Yeah, absolutely.
You know.
No, we are going to look at all of those options. I'm so glad that it came up because that's the plus to the automated system. It's given us some flexibility online and some automatic approval flexibility. So then we don't have to touch it. That's great. Okay. Good.
Sounds like
Good
good
stuff.
communication will certainly help that along, and certainly, hopefully, Cody, in a year's time, it'll certainly pay dividends.
Yeah. Then you do
Ross,
10
I-
boards.
I want to mention something again. I think that we mentioned this to Brian when he was for that time too, about this rotating renewal. You know, instead of it being all December 31st of the odd year, what is required to get that
Change.
to change?
Mhm.
Somebody to go in and say, look, it really is better if you change it, or is it a
So that's a great question. I'm pretty sure that right now it's set in the statute, but my first job in Tennessee was with the board, the attorneys, and we faced exactly that. We had 22,000 active attorneys, and when they renewed in March, our office was paralyzed. So that's the reason I was hired, is because I'd done something similar in Ohio, if a drastic change like that. And they went with, not that you all would have to, but there we went with birth month registration. We figured everybody knows their birthday. So you pick a great cutoff day, give people plenty of time, and educate through the different agencies, newsletters, newspaper, bullet, whatever. This is coming, by the way, attorneys. You're going to expire on your birthday. And we transitioned. So what we did with that board was we got you prorated on one particular year to your birthday, and from then we went live, and you were on your birthday. It's not in the code? Okay.
Check that before, it's not, I knew that.
So if it's not in the code, well, that's why, I'm sure I saw this 12/31st, but in my brain I thought that's a problem for a later date. But to me, a one date that cuts off, and the accountancy board has it, and it is problematic because you have this volume and then you don't. You have all this money and then toward the end you don't. I like the stretched out work. It allows you really and the staff to be able to keep going, and you have that consistency of what to expect. So I definitely think we can address it, and whether we change it to a birth month registration or whatever else. I just happen to know how we did that one, and it was a logical way to do it, but it doesn't have to be that way. I mean, it can be the date that everybody got their license for the first time, because now, we're talking about that one license follows you all the way through. That's your license, and that's how it is actually with most of the boards under Commerce and Insurance. That date you got your first license, that's your date, and let's say you got it on January 7th of 2005. January 31st of every other year is when you're going to renew, and it works. And if we go to that, we can do the same thing. We prorate you 1 year from December 31st, 2017 to your date, and then we switch it. So I think it's a conversation we can definitely keep having. The technology is there. I happen to have talked to the director in accountancy because she's thinking about it, not for this cycle because it's here, but the next one. And what is the logical way to change it, especially when you have, thousands of licensees. It's a good conversation to have.
I mean, you think about it, if you got, let's say you had 1,200 licensees, and you had 24 months in that window because of the rotating birthday month cycle situation, you're only looking about 50 a month. I mean,
it's nothing.
That's almost a no-brainer compared to 1,100 in
it's
3 weeks.
Absolutely. Absolutely. And you, either one, birth month registration or that original license date, the computer system should be able to capture, because I think we've had their birthdays for everything, right? You all didn't have a huge birthday cleanup to do. Yeah.
Does it take some action on our part to get this thing rolling?
I think the board would have to come to a decision of what you want to do. I don't think this December 2017 would give us enough time with everything else we want to do with the exams. But I think once the December 17th renewal goes through, we know everybody's got a license for 2 years. You have plenty of time to decide this is the method, and education is that first piece. I think everyone, would be perfectly fine. You don't lose out financially. You prorate, and then you're on a different cycle.
I think what I might suggest to the members here is to kind of spread this amongst the TAPS organization and get their feel for it. I think it's easy to see where the four of us might go with this, but I think if, in the effort of education and communication, that we certainly could present TAPS and the local chapters with this idea, kind of get a feel for what they think about it. They may have a total different view on it, something that we just didn't see on the surface here in our discussion today about it. But I think it'd be a good idea to just kind of spread the word and kind of get a feel for what they're thinking on it, and maybe come back in the January meeting with a report of what their local areas suggest. Does that sound good?
Yep.
Okay.
Good to me.
I would love that. Yeah.
I think it's a great idea.
It's a great idea.
Great idea.
Thank you.
Okay. Anything further? One item of business that we typically cover at the end of each meeting is the awarding of PDHs.
We're going to go over this application.
Yeah, we'll
If
do
we
that.
had time, or
Yeah, we'll do
we'll
that.
do it after hours.
I think we can do it after.
Okay.
Yeah, because it's not too late. Is the awarding of PDHs for the board members up here? It's 3:30, started at 9. That's 6.5 minus an hour for lunch, 5.5. You want to just call it 5 hours? Does that work?
Settled to me.
5 good for you? 5's good. All right. I'll take a motion for that.
So moved.
Second?
Second.
Further discussion? All in favor say aye.
Aye.
Any opposed say nay. Okay, 5 hours of PDHs. And with that, unless there's other items that I'm missing, I'm going to call this meeting adjourned.
Next meeting is
January.
January 20-something.